I put you in charge.
Appreciate you working with me. Just a second. At one time, this was going to be our last meeting, and this group has a propensity just to move to adjourn all of a sudden and move on down the road. But there's certain people that have really helped us, and even though we have one more meeting to go, I wanted to recognize them at this meeting, and before we can move on to the rest of our business. And if I could ask Rochelle Socorro to come up, and we just want to give her a small token of so you'll remember all of us. And well, Mary Lowry, Mary and Rochelle and Greg, as you'll see in a minute, they send us emails of hundreds of pages to read, and somebody has to put all that together, and they responded admirably every time we call them on. So, Mary, we want to say thank you and hope you'll. Greg, come on up here. Greg's a student intern learning how to be a future county manager. One day he might be here in Alachua County. And so we're really happy to have him as part of our process, too. And, Greg, we wanted you to remember this process, and hopefully you've learned a lot, too. And Shelley Samix. Shelley's up there. Can you come down, Shelley, or are you going to stay up there? She's coming. All right. And but Shelley has done just a wonderful job keeping the television on for us and keeping things running. She has and following us around and keeping everybody. She doesn't always pick up my good side, but other than that, she does great. But Shelley, we wanted to say thank you. These are the staff people that have really done yeoman's work for us, and will continue one more time. And no matter if we're here to 8:30 or 10:30 or whatever time that is, they're here with us and have been there for us. And I know the members really appreciate what they've done. So we just want to say thank you. Thank you all.
I see why he's being reelected.
Oh,
You write some
I don't
checks.
know. Somebody said the other day, they said, "What are you, like the most powerful guy in the courthouse?" And I said, "I'm not even the most powerful guy in my house, much less the courthouse." But anyway, some of you know what I mean there. All right. New business. At this time, we'll open the floor. If somebody would like to, make a motion as far as, or speak as far as how we want to proceed from here. Mr. Grundy, you've been recognized.
I'd like to move forward the question of nonpartisan elections forward.
Second.
Okay, let me just make an inquiry here. As far as the, that's part of an overall package.
Yeah.
Should we start at number one and work our way down? And
Whatever
is that okay?
Whatever the pleasures of sharing.
Yeah, I think that's probably best, but we do have a number of individuals who deferred
Right.
on the
question.
dual vote, so I think
That might-
be the best place to start.
Okay, then we'll begin with, I'll make a motion that he wants to go in order.
Okay, well-
We can begin with dual vote if it pleases the
Okay,
chair.
then that would be question three. Is there any objection to starting with the city since they've been patient and waiting on this time? Okay. But this time then, we'll, Sarah, why don't I ask you to introduce that item number 3 again to us, and then we will recognize the city as you desire to come forward and speak on this issue, and then we'll take a motion.
Question 3 requires a countywide vote and a city-specific vote on future charter amendments limiting municipal power, which are not otherwise subject to the dual referendum requirement in the Constitution, except in certain circumstances. So that a future, this proposal is attempting to affect future charter amendments, and future charter amendments that affect municipal power would be subject to a dual vote, and that means it would have to pass countywide, and if it did not pass in any particular city, the charter amendment would not be effective within that city. There are several exceptions to the actual amendment itself. One is that if the future charter amendment specifically provided that it was going to be countywide, then this amendment wouldn't affect that. The second one would be if the legislature proposed an amendment by special act, this provision wouldn't be effective to limit the countywide application of it, regardless of whether a city voters approved it or not. And then finally, if there is a general law specifically authorizing a countywide charter amendment to be effective countywide, then this amendment wouldn't affect that either. In a nutshell, that's what the
We
question
appreciate
does.
you reminding us of the question. Okay, at this time I'll recognize Ms. Rawlings or whoever would like to speak at this time.
Mr. Chair,
Yes, ma'am.
have we put a motion on the floor?
If you would like.
I think,
Okay.
I mean, that's
That would be
the way
proper
we
way to do
discussed
it.
doing it. I think it's the
Okay.
most
All
appropriate way to
Wait.
put the motion on the floor
Okay.
exactly as the question will be.
Okay.
We're moving forward, because
Correct.
there's a couple different versions.
All right.
Well-
I'll recognize whoever wishes to make the motion.
Since do you want to make a motion?
No, I don't. Well, no, wait, actually, I do. Yes, Mr. Chair, I will move the revised question 3 as currently shown on the screen.
Second.
Okay, it's been moved and seconded that, and in doing that, what we are saying, as I understand, Mr. Brinkman, that you are moving it for the final vote to go to the ballot. Am I correct in that?
That is correct.
Okay, that is the motion, and it's been seconded. Mr. Grundy.
Not necessarily a question, but I have a question to Beth, actually, if that's okay. Whichever she-
She's probably going to speak here in just a minute.
I have a question about before we go. It was related to moving the motion
Okay.
forward and how we vote. Ms. Rollins, I remember, I know how we had an issue last time regarding the language, and I haven't heard anything from the Alachua League of Cities on, what's gone forward, but since we're moving forward with the revised language as it's written, what is the league's position now? Are you okay with having this? Did you want to remove it? Where is your stance now?
The league's position is that the ballot language as is crafted on the screen before you is perfectly acceptable to us. Sarah and I have been working on this morning. This does meet the statutory requirements in terms of number of words, and we are very happy with this language. We do, however, still have a very, very minor discrepancy between our charter change language. The ballot language, we have completely agreed to.
Okay, so you're okay with the language
The
minus?
ballot language, yes.
But as the language is written, it looks like that's what we're going for with the language that's written. So,
Okay, because the charter amendment part's the meat of the
Yeah. There are two things that will be in the resolution before you this evening, or that you will be deciding tonight. And at the moment, they're always married together. One of them is the changing in the actual wording of the county charter. And the other is the description of that change as it goes to the voters. The description of that change, which includes the ballot title, which can be no more than 15 words, and the ballot question, which can be no more than 75, we have agreed on. We do still have we have had great progress on the charter language, but have not yet come to, I don't know any other way to say this. We had had an agreement, and we have language that was submitted there that was drafted by Attorney Bleakley on Thursday, which has since been rescinded. The Alachua League of Cities is happy to accept that language as was presented to us Thursday. The language that was presented to us yesterday is not the language that we agreed to on Thursday, and so we do have a very small clause that we are not in agreement on.
Well, the motion, Mr. Brinkman, correct me if I'm wrong, includes that amendment.
I would say so, and actually,
It's a package deal.
I would like to ask staff, because I'm looking at the agenda packet that was sent out. I believe this is the combined agenda packet, and it has the resolution language in it, and I'm wondering, is that the language from Thursday, or is that the language from Tuesday? And can somebody explain the
item-
differences that are at
yeah, 'cause
issue?
it is confusing.
Ms. Blakely, the item June the 9th is what is currently before us. Your June 9th resolution, and that includes the ballot language. And so that's the motion before us this time. And I believe the difference, if I looked at it right, is that the proposal before us in the motion does not include this portion of a sentence that says, "And the proposing charter review commission, board of county commissioners, or citizens initiative petition sponsor has determined that the countywide amendment fulfills an important county purpose." Is that the only difference?
That is the only difference.
Okay.
We have agreed on an effective date. We have agreed on the minor alteration to the scope that Ms. Bleakley described to you when she went through the amendments at the beginning of the meeting. We have agreed to the provision that the charter change simply require an express declaration of countywide applicability. What we have asked is that along with that declaration of countywide applicability, that the sponsor of the amendment declare it to fulfill an important county purpose. Just that they say that it has an important countywide purpose. And that determination is left in the hands of the sponsor of the of whatever future charter change might come about, whether that be the Board of County Commissioners, a citizen initiative, or a future CRC. That is the only difference in what we're asking for, and that was the proposal that was put before us on Thursday. And we agree to that.
Ms. Blakely, I presume that the words "important county purpose" must have some legal meaning or something. Would you
Yeah.
talk
I'd like
with
to
us
hear
about
her
that?
version.
Let me answer your first question. It was something that was emailed out today and should be in your packet.
Okay, that
It looks
would
like,
be-
looking at an agenda packet, page 62 through 64.
It says question 3 revised as of June
That
9,
would be the
2000.
combined agenda.
Pardon?
The combined agenda only goes up to page 54.
How do I hear it?
Okay, you're not using the hard copy. Okay, that makes sense.
Well, here,
Yeah, that's,
the one that was emailed out.
But it's
You talking
the
about-
document dated today, right? There was no
Yes.
other document dated today.
There was nothing sent out between
think I
last
got
meeting and this meeting other than this June. Mine doesn't have a date on this particular one for some reason.
Mine on the top says June 9, 2010, question 3 revised.
Right.
Okay. And the only difference between the two is that one phrase that I just quoted. Okay. Please do. That would be very helpful. So we've got both, this is your, the one with, okay, and you've marked it. That's great. Thank you, Beth. See if that's enough.
Where to start?
Okay.
Start right at the legal issue involved. This is what they have?
Yeah, that's
Okay, so the
exactly.
bracketed language there in paren D, Beth calls it a threshold, that before, well, okay, so you left it like this. Okay, sorry. The proposing Charter Review Commission, Board of County Commissioners, or Citizens Initiative petition sponsored has determined that the countywide amendment fulfills an important county purpose. We talked about lots of other variations of this, but, okay, this is what you're proposing now. The problem, the legal issue that is involved in this is that it attempts to trump the Florida Constitution that allows for amendments to be approved on a countywide vote, and it puts a limitation on that. It's got to be important. The Constitution doesn't say anything about a charter amendment being important or unimportant. It just says a charter amendment is approved on a countywide basis. The second issue that I have with this kind of concept, the legal issue, is that there is a statutory provision right now in Chapter 125, that's the county chapter, 125-68, that specifically authorizes and says that is this is the specific legislative intent to recognize that a county charter may properly determine that certain governmental areas are more conducive to uniform countywide enforcement and may provide the county government powers in relation to those areas as recognized and as may be amended from time to time by the people of that county. I don't know how this relates to what's, this proposing important has to be important. Certainly doesn't track the language, and it may well be inconsistent with this language. If it's inconsistent with this language, then it violates the constitutional requirement that the county doesn't have powers that are inconsistent with general law. Whether this important county purpose is more or less, I don't know, but the legislature has certainly given counties the specific legislative authorization to have county charter amendments that are uniform countywide enforcement when they deem it properly determined, that is the desire. And then, of course, the people vote on that. So is my problem with this language. And in fact, when I drafted this language, as if you'll see this is something from me, I was trying to make sure I understand what her concept was, and I wasn't trying to express my agreement that this was lawful. So, and I'm sorry that we had a miscommunication.
Appreciate your comments there. Further questions?
Mr. Chair?
I'll come back to you in just a second. Let me recognize DJ here first.
This is my question. I'm just curious, who would define what is important?
Well, under this version of the, you want to answer that?
No, go ahead.
Is this your thing? Okay, under this version, I mean, we went back and forth about who would make that determination, and I'll let you speak to other alternatives if you want to. But under this language, it would be up to the Charter Review Commission, the Board of County Commissioners, or the sponsor of the Citizens Initiative petition that was putting forth the amendment for the voters to consider.
That's what it looked like. Okay.
Mr. Chair, could I just ask about, so when you say the Charter Review Commission, you mean we would have to provide examples of what we think is important?
I think she's saying some future.
Is that what you're
amendment.
saying, or is
This would be something in the future.
in the future? Oh, okay.
Yes.
That if
This would
we,
affect
10
future
years from now, if
charter
they did it and this was in there, then this body would have to, or that body would have to declare it as an important county purpose. Further questions, David?
Yes, Mr. Chair.
Martin, then
Ms.
I'll-
Rollins, maybe you can enlighten me. Is the purpose of that language not to dispute the authority or the power to state a county purpose, but was it just to articulate what that was, to put it before?
It simply is to articulate that, that future amendments that deal with the limitation of a municipal power should have an important county purpose to the limitation of that municipal power. If,
Well, I
ahead.
guess, like, when you're saying, are you asking for them to specifically say this is an important county purpose because A, B, C, and D? Is that what you're hoping this language would accomplish?
I do hope that this language would accomplish that. I'll tell you what has essentially happened here is that we started, as you know, quite a ways apart, and we worked very hard to resolve our differences, and we got to a place where, in order for us to accept the simple declaration of countywide effectiveness, because as you recall, the last time I came before you, I said simply putting the word countywide into an amendment does not accomplish what we're looking for. But we heard that you wanted to hear countywide effectiveness and that you wanted it written into the language. So all we've asked for here is that in order for it to be put forward as a countywide initiative, as a countywide effectiveness, that the sponsor of that change make the declaration that it serves an important county purpose. It's not a big thing to ask. We're asking anybody who puts it forward, whether that be the Board of County Commissioners, a future CRC, or a citizens group, just examine what they're doing and say, if we want this to be countywide, it does fulfill an important county purpose.
Ms. Blakely, so by requiring that our specific articulation of how it's an important county purpose, that's inconsistent with the Constitution in some fashion? Is that what you're saying?
Well, the Constitution certainly doesn't require that the issue be important. I mean, doesn't require a declaration of that or any factual basis to tie that up. However, the statutory provision says that it has to be conducive to uniform countywide regulation, is what the statutory basis is. And as you recall, I talked about those cases that found the difference between what requires dual referendum and what doesn't. One of them was a District Court of Appeal case in Volusia County, where they have a wide variety of regulation for the beaches empowered to the county, even though one city disagreed. And they relied in part on this provision that said, they went through a whole process of, how do we get a hold of the problem that we've got? We don't have access points. We've got different charges for wherever you go in to access the beach. We don't have we got different cities providing services on the beach, different lifeguards, all kinds of stuff that was not uniform. And so they got together, a group of folks, every city participated except for one, and they came up with this proposal that passed throughout the county except in one city, and that one city filed the lawsuit, and the district court said, in part based on that process they used and the determinations they made, that the regulation of beaches was conducive to uniform countywide enforcement. So that's my issue. Is that an important issue? They didn't make that determination. I guess it's inherent in that, but they certainly didn't make that determination. Where this important county purpose concept comes from is a whole other constitutional provision. I'm hesitant to insert that here, but it's Genesis. There's a provision in Article 7, the Tax and Finance article of the Constitution, that limits the legislature's ability to pass legislation that imposes a mandate on cities and counties. It's A through D, so it's pretty long, and if you've been around long enough, that's what cities and counties are always complaining about. Well, I guess in 1989, this amendment was put to the voters, and they adopted it. It has some effect. There have been some litigation over it, and one of the provisions is when there are several different provisions, but one of them, A, is an expenditure requirement. The legislature requires a local government to spend funds, then they've got to either give them some money or they've got to say that it, or they have to say that it meets an important state interest. Let me see if I can find the language. An important state interest. And pass it by a 2/3 vote. What does that mean? Well, there's been some litigation that a bare statement in a piece of legislation that declares, hey, this is an important state interest, is not enough to meet this constitutional requirement. There has to be some articulated reason why it is important. Does that apply to this language that's being proposed, that the proposer of a charter amendment in the future is going to have to determine that the countywide amendment fulfills an important county purpose? I would think so, in some way. Somehow they couldn't just say, hey, this is important, so let's put it on the ballot, and if it passes, great.
Okay. Thank you for your comment. Mr. Ackerman, did you wish to be recognized?
I didn't, but I'd like to ask a question for Ms. Ross, and this is a more generic
I understand.
term. Just a minute.
No,
I'm just puzzled by the whole concept of this amendment, because at this point, municipalities are exempt from all but a little bit of county authority. You know, there's a whole range of things that they can opt out of or that they're not subject to. So at this point, we're dealing with a little tiny sliver of authority, and it's very difficult for the county to exercise because they have to do it by charter amendment, which means they have to go through the process of public hearings, and then they have to submit it to the voters. If we say, you know, it has to be an important county purpose, or we don't say that, at this point, we're not doing anything. I mean, we're in the same place we were before, and why are we going to put all this on the ballot and when nothing really is going to change? And I'm a little puzzled too because I can't quite. Y'all have given us some, quite frankly, lame excuses of the fears that you have. You know, that the county electorate's going to outlaw horse riding or I don't know what. But the only example that the county's ever done is exercising countywide control over air and water pollution. Well, if ever there was something that appears to be a countywide issue and needs to be regulated countywide, that's got to be one of them. I mean, we don't want to have a municipality opt out and say, we're going to bring the nuclear waste dumps and just dump it out all over the rest of the county.
I agree.
And there's got to be a lot of other things that I can't come up with, quite frankly, but y'all can't come up with them either. And so then I begin to think there really isn't all that much stuff out there, and I just don't get it. You know, I don't understand why we're going through all this effort and why you've gotten all of the municipalities on board on this thing, and I haven't gotten a good example of what exactly you think is going to happen when this is here.
Well, first off, I would say that the fact that all these municipalities have spent so many, many months trying to come to agreement should have some weight in your deliberations to begin with. I'm sorry that you don't understand our
I'm
position.
just dumber than the rest of them.
But despite the fact that maybe some days that have been presented to you have not rung true for you, there are myriad examples all over the state of county charter amendments being used to usurp or alter municipal powers. They've been done on land use, it's been done on annexation, it's been done on regulation. It has been done in any number of ways. And while there is not an egregious thing that we are trying to fix here, I can tell you that that little piece that you think is so very, very small is so very, very important to us. And so if it really doesn't matter, please, we've worked very, very hard on this. We have all passed resolutions. We have met with you individually. We were tasked with the job of working with your council to come up with language. We have accepted the language that she drafted less than a week ago. We are prepared to move forward with this. We have done everything that you've asked us. We've given you your countywide declaration. We have done what you have asked of us to do. And we're here today to say, please give us this.
Mr. Chair?
Thank you very much. I was going to recognize Mr. Grundy first, and then
Okay.
Mr. Grundy.
Mr. Brinkman, I know we have a motion on the floor, but it appears that, Ms. Rollins, with all due respect, that we are at an impasse, and it looks like, and Mr. Little said something, Commissioner Little said something at the last meeting, but we have spent a lot of time on this. We've worked. I mean, we've tried to get you all to work together. This is the language that's on the table. This is what we have to move forward with. We tried at the last meeting to go forward with the language that we did. It failed. At this point in time, I mean, we really do need to move on. There is another option that you do have to go for citizens initiative, but I mean, if you're not happy with this language, I mean, it looks like we're in an impasse. And if you're not in favor of going with this language, I'm prepared to table this today.
We are in favor of the language as drafted on Thursday.
But the motion, I had Mr. Brinkman first, and I'll come back to you,
All
Ashley.
right. And thank you, Mr. Chair. For clarity, so that we all know what we're talking about here, as I said, the ballot language as on the screen, the revised version, and the
Supporting
resolution language as sent out by our attorney today without the phrase that Ms. Rollins would like. That is what I am motioning. I'm now would ask the seconder if he wants to withdraw his second or not.
Well, no, I guess.
Otherwise, I'd say let's move
That's the
forward.
motion. That's the motion.
Yeah, I'm going forward, but I'm still keeping my second on forward.
Okay, well then, that is the motion on the floor. I don't think we're at an impasse. Let's move forward, hear from the commission, and then
Let me recognize Mr.
in the
Wood.
public and vote on it.
I think we had
I would amend your motion to reinsert this clause back into the amendment. And in this manner, we could move forward with this as far as you all are concerned, and we can discuss at least this part of it and vote on it, whether we add the amendment back in or not, and then move forward to bring this to the ballot.
For clarity, you are referring to the resolution language, and you're referring to the specific sentence.
She has in brackets.
And the proposing Charter Review Commission
Right.
Board, et cetera.
Well, with all due respect, I don't accept that amendment, so.
I don't know that we got, did Mr. Wood make the
You
amendment?
made a motion.
I made the motion to
Okay,
accept
so you're making the motion that we amend the original motion by adding the section in brackets, as we've read a couple of times here tonight. And Mr. Martin, you're seconding that
I
motion?
second that.
It's been moved and seconded, then that we amend the motion by adding that, so we'll open up for discussion on the amendment. Any further discussion on the amendment? Recognizing any citizen that wishes to speak on the amendment. Mr. Martin, I'm sorry.
Yeah, I'll be very brief, because everybody knows that I've been one of the first ones to bring this up, so I think everybody knows how I feel about it, so I won't rehash all of that. I will say one thing about it is that, two things, actually. Home rule is really what drives me through all of these various issues. Now, I'm not a legal scholar, so, I'd be willing to entertain the fact, I think I stayed at a Holiday Inn when I was going to Tennessee for the Gator game, so whatever. Anyway, if our attorney is telling us that there's questionable constitutional, Mr. Little is saying as well that, I don't want to put words in his mouth, but I think he has said that in the past. I would be wrong not to at least listen to them, and I have listened to them, and I am willing to push this forward. But at the same time, I do believe we need to move forward. And the last thing I would say is something Ms. Rollins said, and I would also kind of echo this, because I have sat where a lot of these ladies and gentlemen have sat, and they would not be up here spending their time, sitting here through all of this meeting, waiting on all of this, if they did not feel that it was a very important issue. Now, I'm not asking you to vote on something you don't believe in, but what I am asking you, we've all said over and over again, I've heard it said, that we want more evidence, we want more of this, we want more of this on every single issue. I've noticed that people only want more evidence on issues they're opposed to and not those they're in favor of, but that's another story. I would say that you'll not find more grassroots, more people who have voted, including attorneys who have looked at this, than you will find when all 9 municipalities unanimously supported this issue. There must be a problem that they believe needs to be addressed either now or in the future. I would ask you to give serious consideration on that when you vote, and that's it. Thank you. And I applaud y'all's willingness to come out.
Commissioner,
Thank you very much.
Chairman.
Recognizing Mr. Martin on this side.
Yeah, I know this is a rarity, but I find myself agreeing with the other Commissioner Martin. More on form rather than substance, and don't read too much into that, because what rings true to me is that sometimes when we are really embracing a particular issue, regardless of whether or not it's on shaky legal ground, we by hook or by crook, we're going to figure a way to push that over. But when it's something that we don't want, it seems to me that it doesn't say that in the Constitution, therefore we can't do that. That seems to be pretty inconsistent to me with some of the statements I heard this evening. So I am willing to continue to hear more input on this issue.
Okay, we're about through talking about it. We're down to the amendment, Mr. Grundy, and then I'll recognize Commissioner.
And it's not that I don't agree, Commissioner Martin, it's not that I don't agree with that continuance, but I think we really have talked this issue to death. I mean, we've talked it to death, and I mean, I will, everybody that knows I supported this. But again, the vote that we took last time was very clear what this dais felt about the issue. And I really believe it's time to move this forward. So that's what I'm prepared to do, so I want to call a motion to question.
We have to hear
Okay.
from the public.
We got to hear from the public.
Oh, yeah, I know that. That's,
Okay, well, there's no second on the call to cut off debate, so I recognize Commissioner Travis. If you wanted to come speak, you're president of the League of Cities, I believe, now.
Thank you, Mr. Chair. Just a couple of things. Some facts that came out tonight that we have 230,000 citizens in Alachua County. 145,000 of those are involved with the 9 municipalities. That's 125,000 from the city of Gainesville and 20,000 from the municipalities. The issue that we have is that our amendment was brought in public hearing twice in each one of our municipalities. It has been brought before the people in each one of our municipalities. So over 50% of the citizens that live in this county have said they want this amendment. I think we have tried to work. We're very much acceptable of this language. There's the one language about the purpose I think is strong. But we have done all I think you've asked us to do. And, you know, I take offense at people talking about illustrations that we use. And when you talk about the issue of the horses, that was done, I'm not talking to you, Mr. Chair. I'll get away from that because we don't allow it in our chamber either. That was not something that was pulled out of a hat. That was actually a citizens' initiative in the city of New Bern, North Carolina. So what we're talking about, if you don't do this, it is a degradation of home rule. We have the ability to rule ourselves. Anything that you do, we should have the ability to say no. So this language we've tried to put in here is to make that happen. I'm in complete agreement with this. I think the League of Cities is in complete agreement with this. But you all are not elected. You are not elected. You are appointed. We have to face the people that elect us. If they don't like us taking and putting this amendment before you, then they'll tell us because they'll vote us out. And I think that should be one very serious consideration that you have. This isn't appointed. We weren't appointed. We were elected by the people. That's where we are. We live in this country. We are elected by people, not appointed. Not appointed by a county commissioner, elected by the people. And we have had a county commissioner tell us that we only represent 2% of the electors in this county in an open meeting. So, gentlemen, ladies, give us the opportunity to have our own rule. Give us the opportunity. Don't degrade our illustrations. We're not the country bumpkins. I have a master's degree from this great institution.
We appreciate
So please, give us the opportunity. I see my red light on. Mr. Brinkman, you've got a really good finger there. But thank you. Give us the opportunity to let the people decide. Not you all. That's all I ask. Thank you.
Thank you, Commissioner. Mayor, did you wish to speak?
Yes, I do.
Please, you're recognized. Mayor Sutton.
Richard Shuttley, Mayor of Micanopy. And last night we had our council meeting, and the only resolution that we had was Ms. Blakely's Thursday resolution. We discussed it, and we are in agreement with it. We're in agreement with this letter, and I would urge you to move forward with that amended motion that you have. And to address Mr. Ackerman's, very briefly, his question, I dealt with the Municipal Fire Authority. We were in that for a couple of years, just about trying to get unified contracts. And one of the issues that the county has the ability in its charter for regulatory it would be, for instance, a number of firemen on a fire engine. Now, Micanopy's been around a long time. We've had our fire department a long time. Chief May at that time was putting forward that maybe we might need to change the county regulations so that we would have to have 4 men on our fire truck. Well, we follow all the state, all the FEMA. We've got 2 fantastic engines that we have to take to Stark and have kept up to date. We follow all the state regulation on how many men we have on our engine. But a charter amendment could require us to have 3 or 4 men on that engine. And that would put Micanopy's fire department out of business. And it was at the time when we were doing negotiations that more than one county commissioner stated that the goal was to eventually have a single county fire department, no matter what the means. Now that, if you want to look back at the records, that was stated. And one of the means would be to require us to put more men than is normally mandated, and more men that we could afford. And we already have 2 municipal fire stations in this county that this year could not maintain the means for their fire departments. We don't want to fall that way. And this is one of the reasons we're so adamantly for this, is that it's just a single one of the possible protections we could look at. Because an amendment like this would allow us to say, no, we're good with 2. The state says we're good with 2. FEMA says we're good with 2.
Okay.
So, thank you very much.
Appreciate it, Mayor. Appreciate your time. Further comments, Commissioner?
Good evening. I'm Roberta Lopez. I'm the mayor of Archer. And I'd like to commend all of you for the work that you've done and that you are doing. I'm here speaking on behalf of the Florida League of Cities as well, and I'm also a member. And I would like to ask all of you to support Beth's amendments and recommendations, please. Thank you.
Thank you, Mayor. Appreciate you being here tonight. Please come forward. Yes, sir. Mr. Mayor, good to have you with us tonight.
Thank you. I was just here last night. It seemed like I'm living up here.
I know it.
I don't usually speak, but I did last night. But again, Newberry is here, and they said that we need to show our presence. And some of you don't know that I'm the mayor of Newberry. I'm also vice president of the League of Cities. Newberry is like a football team. You know, if one person pulls the other way and the other people pull the other way, you never get anywhere. So we're supportive of the League of Cities. Thank you, Mr. Chair.
Thank you, Mayor Nichols. And as a young man, I played Newberry in high school in football, so I played pretty well.
What position you play, Mr. Chair?
You just wouldn't believe how fast I used to be.
What position you used to play?
Really? What position did you tailback, man. All state.
Louis Davis, Mayor of Waldo. I just want to say the City of Waldo is in support of the language that's presented to you tonight with the amendment, and we support it. Just don't tell them how long ago you played football.
That's right. Appreciate that, Mayor. Thank you for coming. Mayor Lowe, nice to have you with us tonight.
Hello, Chair and Commissioners. I am Craig Lowe, Mayor of Gainesville. The City of Gainesville did pass a resolution in support of home rule for municipalities, and the language in the amendment is in keeping with that resolution of support, and I do urge support of the amendment. Thank you.
Thank you very much. Appreciate your time. Other comments? Yes, ma'am. Please come up.
Good evening. I'm Lori Costello. I'm Vice Mayor of Archer, and I want to thank everybody, each one of you, for all the hard work that you do. Please support the small municipalities and pass this verbiage tonight. I beg of you. Thank you so much.
Thank you. Appreciate that, Vice Mayor. Other comments? Mr. Manager.
Good evening, Mr. Chair, members of the Charter Review Commission. I'm Jim Drum. I'm the city manager for the City of High Springs, and I'm also here with the Alachua County League of Cities. There's been many examples and things that have been brought up, and I know I've given a lot of discussion at the previous meetings, but we would ask tonight that at our last meeting, we were asked to work with your attorney and your staff to see if we could do something to come to that agreement, and we weren't that far apart on our wording, and we feel that we've really negotiated in good faith, and that we've come to a pretty good place in the middle, and I think we have, again, as we have negotiated, and we would just ask you to take this and approve it tonight and take it to the voters and let them decide. Because we do think it is for the best of all of our communities that we look out for the home rule of our cities and our towns and self-governance. Thank you, Mr. Chair.
Appreciate that, Mr. Manager. Other comments? Yes, ma'am.
At the risk of sounding extremely uninformed,
You'll introduce us.
I'm Susan Baird. And 2 meetings, 3 meetings, ever since the beginning of these meetings, I've heard this amendment. I have no idea what that says. And I've been here at 3 meetings, and I've been trying to figure this out, and I still don't know. I can't even imagine what it's going to be like if it goes on the ballot. Nobody's going to have a clue as to what you're talking about. The little bit of argument that I've heard so far and the pros and cons and the reasoning behind it, and again, that value of true representation makes me think that this is a good thing. Don't know exactly what it is, but it sounds like a good thing. And that's probably a little bit of the whole gist of your roles, because it's so hard to know everything about everything. So when something is good for the better representation of people, I think then therefore it should be put on the ballot. But figure out a way to explain what this is so people can vote correctly or whatever. Thank you.
We appreciate it, Ms. Baird.
And Ms.
Thank you so
Blakely
much.
looks at us and
Further comments on the amendment?
please, let's move on.
Any members wish to comment on the amendment? Mr. Grundy.
Motion to question.
No, I'd like to make a comment on that.
Okay. Mr. Little.
Mr. Chairman, as you know, I think this is frivolous. I think this is a nothing motion. I think it's in violation of the Florida Constitution, and I think it's bad on the merits in the sense that it takes away, or would if it were valid, take away from the county voters to determine that there needs to be county regulation on a particular matter. I would be very critical of the speakers that have spoken. I wish we could cross-examine them. I wish we could put them under oath and ask them the basis of the statements that they're making, because many of the statements are just flatly wrong. The matter of delivering fire services is the delivery of a service. That's covered by Article 7, Section 4 of the Florida Constitution. It's not covered by this, and this would have no effect upon it. And the same thing is true of some of the other things that have been mentioned. I don't know how this committee got captured by somebody from out of Alachua County who came into our county and organized these nice people, earnest and sincere, but just wrong in their views. How that happened is just a puzzle to me. And how this board permitted ourselves to use half of our time or more during the entire 9 months on this matter is absolutely a disaster, in my opinion. So I know the proclivities of some members of the board, and we're going to vote, but I want to just put it on the record, as they say, that this is a fiasco. And I hope that, in fact, we will defeat it. Thank you.
Thank you very much. All right. Not seeing any other hands, I think we're ready to vote on the amendment. The amendment before us is to add the language in Section D of this amendment, which is in the proposing Charter Review Commission, Board of County Commissioners or Citizens Initiative Petition sponsor has determined that the countywide amendment fulfills an important county purpose. All right. Mary, I think you're going to need to call the roll. Greg's going to call the roll. All right, we'll train him to call the roll. You'll call the roll then and announce the vote for us.
All right.
This is on the amendment only, on the amendment.
Mr. Ackerman?
No.
Mr. Brinkman?
No.
Ms. Ferguson? No. Mr. Glazer?
Yes.
Mr. Grundy?
Yes.
Mr. Irby?
Yes.
Mr. Little?
No.
Mr. Martin? Abronsi?
Yes.
Mr. John Martin?
Yes.
Mr. Richards?
Yes.
Mr. Tuttle?
No.
Ms. Martin? Mr. Wood? Mr. York? 9 yeses.
Thank you very much. 9-5, I believe. All right, 9, this, by your votes, then the amendment is agreed to. Now we'll place before you the motion as amended, which includes that wording now in this section. Is there any discussion on that?
This point of information, so if that's going to add letters, I think it was at 78.
That was not in the ballot language. It's not in
Okay.
the ballot language. Okay. Other comments? Okay, I'm not seeing any hands, and so I think then we're ready to vote. Then we'll vote on the motion as amended, which is now the, actually, that just takes on the proposal that was distributed earlier by the city, which includes those words. So Greg, if you'll call the roll again for us, please, sir. Motion as amended.
Mr. Ackerman?
No.
Mr. Brinkman?
No.
Ms. Ferguson? Mr. Glazer? Mr. Grundy?
Yes.
Mr. Irby?
Yes.
Mr. Little?
No.
Mr. Abronsi Martin?
Yes.
Mr. John Martin?
Yes.
Mr. Richards?
Yes.
Mr. Tuttle?
No.
Ms. Martin? Mr. Wood? Mr. York?
Same vote.
9 yeses, 5 noes.
Thank you very much. Well, those of you that supported the amendment, it is now on the ballot. That concludes, we won't be discussing that matter anymore in this group. And so we wish you well. We leave it to y'all to explain it, as some of our members have said here.
Just quickly, thank you all for that vote of confidence in where we are with this. We all want what's best for our citizens. We don't all agree, and I've had the opportunity to talk to Professor Little on a show. But I do appreciate you all considering where we are, and thank you for your guidance in this matter.
We appreciate those comments, and I think everyone here realizes that we all have the greatest respect for our municipalities and our municipal leaders, and we'll now turn it over to the voters. All right.
Chair, could I ask a
Mr. Mark.
procedural question?
Yes,
Just
sir.
because you made a statement, and it's not in relation really to this, but we just voted, so you said it's on the ballot.
That's right.
Does that mean, because I'm saying this for future, that someone could not, as they have done with some other issues, vote to reconsider that? I'm not talking about this. I'm just saying, once we cast votes from here on,
We have one more meeting.
I'm only asking it because it's come up already. It's not about this issue. It's just in general.
Anytime a motion, the floor is open for motions, that motion would be in order if you voted on the prevailing side and so forth and so on, yes.
Okay, that's
Okay?
all I wanted to know. Thank you.
But we don't anticipate it. Once we've reached this point, I think we're pretty well set.
Well, I hope so too. 'Cause-
Mr. Chair,
Mr. Brinkman.
I'd like to make a motion for something
Yes, sir.
I hope will be a lot less controversial, take
I hope
a
it's
lot
number
less
one.
time.
I hope it's
Question
number
1, yes. I'd like to start back at the beginning. Let's do question 1.
Thank you for that motion. Is there a second? It's been moved and seconded, and then that we refer to the voters, the citizen initiative petition requirement amendment proposal. This changes the amount of petitions required to initiate a county ordinance from 7% to 5% of the total number of electors as of the last preceding general election. Your motion includes not only the ballot language, but the
Resolution.
the attendant resolution that was prepared by our attorney. And let me just look at mine real fast, but that's the motion. Did I receive a second? Yes. Where's?
Mr. Woods.
Okay, thank you.
Mr. Chairman, I'd like to make a short speech, if I may, at this point in time.
You're recognized, sir.
Okay, thank you. And the reason I'm doing this is because it addresses some of the questions that have come before us. And the first has to do with the role of the committee. And in my opinion, we've got a role of investigating the need that the county has to have some change in the charter. A job I think we have not done very well, and I don't think there is any great need for changes in the charter. We have a job to hear what the public has to say. I think we have done more than we needed to do in that regard because we got a lot of repetition, and we got captured, in my opinion, as I said a moment ago. We need to propose things on our own that we think would be beneficial to satisfy some need in terms of modifying our charter. And we haven't come up with much in that regard, which I think speaks pretty well for our current charter. And we need to evaluate, to try to make a determination whether or not this is a thing that would be beneficial to the to the county if, in fact, the people of the county were to adopt it. We haven't done too much evaluation yet, in my opinion. I certainly reject the notion that the committee ought to accept anything that is thrown out there, that I think the committee just did on one. So I'm criticizing the committee now, which is my prerogative, I think. Our job is to evaluate and to send forward only those proposals that would improve county government in Alachua County, not simply to say, gee, we're giving you a chance to vote on something. That is demeaning and derogating of our responsibilities. What the committee did least best is evaluation. I'd like to say that one of our members, Member Ferguson, early and repeatedly asked for studies and reports. And apart from legal matters, we didn't do any of it. We didn't do any of it. The committee heard a lot of opinions here. Some of them good, some of them ridiculous, and some of them bad. The little evidence, little scholarly studies were produced to back up any of these things in terms of the likely effect upon the governance in our county. Single-member districts is a good example. We started out with a notion, and this was the thing that had some ring to me, that single-member districts somehow would improve the representation of rural voters. Well, we don't have any evidence to support that, and the demographics of our county plainly, logically refute that. There's no reason whatsoever to think that going to single-member districts is going to make those people in the rural areas feel any better about their representation or to have any different representation than they now have. So in my own mind, that notion has completely lost any support on that particular grounds. The same for nonpartisan elections. I haven't seen anything that would lead me to think that changing would be better for the county. Some people's opinion is that it is. Some people's is that it would not. I don't see any reason simply to throw it out there because somebody thought it's something we ought to consider. We ought to decide whether this is a thing that's likely to lead to some improvement in the way we govern ourselves in the county. So that's the basic question. And I understand some people rebel at this, but I think in a county that's well governed, as ours is and has been for a long period of time, that the status quo is in fact the starting point. And if we're going to change it, there ought to be some presumption or some evidence or some basis to rebut the presumption that the status quo is not good and not the preferred position. Now, one thing I want to mention in terms of what was just done and what the voters are going to think, whether you like it or not, the voters are going to be told by people that this is a recommendation, whatever we approve, of this committee. Not that this committee simply decided to put it out there and let you vote. So whether you like it or not, there's going to be one side on every issue that says this is what the committee thinks you ought to do. You see, so we in fact, after we adjourn, are going to, as a committee, have no effect apart from that lingering effect that somebody's going to take advantage of. And I think that ought to be lead us to think a lot about it. We know how electioneering goes. Sound bites, slick stuff, the actual Discussion of the issues is going to be very slim. This thing you all have just put on the ballot is going to be a total disaster in terms of the electorate in our county. And I think you ought to think, and that's a nothing issue. So it really does. It's like the pigs in the pen thing we have in our Constitution. It's a terrible thing to be in the Constitution, but it has no effect, so who cares? You see, and that's what that's going to be like. But some of these other things that we're going to discuss are important, I think, in terms of what we do. So I think we ought to not simply think that, well, what we want to do is to throw out a ball there and let somebody start kicking it around and just see where it goes. We ought to decide that if it passes, we're going to be better governed in our county. And these remarks are going to strongly influence the way I vote now on these substantive issues that come before us. And I just wanted to put them on the table. Let me also reveal, and maybe the public would be interested in this, I'm a registered Democrat. And of the organizations that appeared before us, some people find this hard to believe, the only one that I'm a member of is the NAACP. And I'm not active locally at all. I'm a member of the national organization. Other than that, I don't have any ties to anything that's come before us. Thank you, Mr.
As always, we appreciate your comment. Further, we have a motion on the table, which is question one. Or is there further comments on the motion?
Well, I'll talk about it briefly. Having just been involved in a citizen initiative petition drive, through a certain amount of research, we understood that this is only the third citizen petition drive that's been successful in Alachua County. I believe the first one had something to do with a cement plant out near Newberry, but it wasn't successful when it was voted on. The second one had to do with gender issues, and apparently this is the third one. And I just, looking at the fact that there have only been 3 that have come before the citizens means it's an awful lot of work to collect 7%. And I know a lot of you saw us out on the street doing that and how much it took to do that. And I really think that if it is brought to 5%, it will make more people think that it is doable, because there was a lot of doubt along the way of getting those petitions signed whether it was going to be doable or not. And if not for the Spring Arts Festival, we would not have been successful. So, but lowering this to 5%, I think, is the right step. I agree with Commissioner Little. I do think this is a good thing for Alachua County. I think it's a good thing for the citizens to become involved in government and to be able to put on the ballot initiatives that they feel are necessary that are countywide, that are really county issues.
Any other members wish to be? Mr. Brink.
Mr. Chair, I'll just be very briefly kind of going to comment some comments that Commissioner Little made. We've been told many times that we should just put everything on the ballot and let the people decide. Well, I don't think that's our charge, and in fact, people do have the ability to do that for themselves if they want. If they want to put a charter amendment on the ballot, they can go out and collect, I believe it is 10% of the signatures. They have 180 days to do so, and then that item will appear on the next ballot. So, if people are dissatisfied with the actions of this committee, it's not like we're preventing them from voting on anything. They can do it themselves. They could not make the 2010 ballot, but as Commissioner Delaney pointed out, they'd probably have a much better chance no matter what they had by putting it on the 2012 ballot.
Thank you for those comments. Other comments, Mr. Grundy?
It's hard to follow Commissioner Little. Commissioner Little talking about his party. I mean, be careful, Commissioner Little, because now they'll say you're a proxy for those who appointed us because of your partisan affiliation, or the other one is you're racist because you disagree because we can't think for ourselves. I think Commissioner Little is a testament that we can all think for ourselves, and we do hear you all. But I concur with everything everyone has said.
Thank you very much. Mr. Martin, John Martin.
Thank you, Mr. Chair. Just so that, because I'm about to make a couple remarks, and I'll get to the end at the beginning. I'm going to support this for several reasons. Not necessarily because I agree with it. I mean, we've heard eloquently people speaking about the status quo and those types of things, and how we We don't want to, we don't want to put this out to vote, which I'm sure we'll hear it, others, and all those types of things. But it's funny how when if the status quo is fine, then why do we need to lower the bar for this? I think you can make a strong case that if it's a great idea, then why does it need, and you can't get 7% of the people to support it, then how great an idea is it? Now, I'm telling you, I'm going to vote in favor of it, okay? Because I do believe in trying to get more participation. I tend to vote on the second one as well, although I'm not necessarily in agreement with it, because contrary to what some people may think about me, I actually don't really have a big agenda. I really, and the whole issue when we get later to talking about some other issues are not based on any one particular thing. As a matter of fact, I think I could probably make a strong case that some of the things I have supported, and I'm a lifelong Democrat, and probably will support here down the road, probably won't help my chances if I wanted to seek some other position, if I wanted to. But that's not why I'm here. I'm here because I believe in voting what I think is right. And one thing you'll know from me, I have not challenged anybody, even people who were totally opposed to me. I have not personalized it. I have not one time said that I didn't think you were discussing your conviction, but yet I have heard time and time again, not necessarily directed at me, issues like we need more study, but it only comes from people who are opposed to the issue we're talking about. You never hear them say I hadn't heard anybody say we need more study on this issue at all, especially the people who are supporting it, yet they will turn around on another issue and say we need more study. So what I'm asking is basically for us to try to put aside our personal agendas, personal beliefs, and if you truly don't agree with something, then certainly vote against it. But to demonize the other side of an issue simply because they disagree with you and insinuate that they haven't studied it enough, or that they have some type of hidden agendas, or they represent a certain people, if you're not willing to question your own beliefs, you absolutely should not question someone else's. So I'll say this so I don't have to make this speech on other issues. I'm supporting this because I believe that it is actually very difficult, as been said. I'm not sure that it's going to be that much easier to get 5%, and I would say what I said at the beginning. If it was such a great idea, how come you can't get 7% to do it?
All right. Thank you very much for your comments. Any other comments on this? Let me recognize any citizen wishing to speak on this issue. Seeing no hands anywhere. Okay, I think we're ready to call the roll on question number 1. And again, this is the question. This vote is to accept the ballot language and the corresponding resolution that will place this on the ballot. And so, call the roll.
Mr. Ackerman?
Yes.
Mr. Brinkman?
Yes.
Ms. Ferguson? Yes. Mr. Glazer?
Yes.
Mr. Grundy?
Yes.
Mr. Irby?
Yes.
Mr. Little?
Yes.
Mr. Martin? Abronsi? No? Mr. John Martin?
Yeah, but I wish we'd studied it more.
Mr. Richards?
No disclaimers allowed.
Yes.
Mr. Tuttle?
Yes.
Ms. Martin? No. Mr. Wood?
Yes.
Mr. York?
Yes.
11-2?
Move number 2, Mr. Chairman.
Okay, we need one more vote in some
Lost a vote.
Oh, 12-2.
12-2? All right.
Thank you.
12-2, by your votes then, that will show that question, we had 14 votes. We have one now. Anyway, by your votes, you've adopted question 1, and we will prepare it for ballot. And again, without objection, I would repeat again that in the end, we may have to renumber some of these things and all, depending on your votes, and so we'll accept them all, knowing that we may need to make some technical or conforming changes or correct some scrivener's errors as we prepare this for the final presentation. Anyway, okay. I heard somebody say moving to Mr. Little is recognized moving number 2, question number 2. This is a limitation on county commissioners' authority to amend or repeal ordinances approved by the city citizens initiative. And I think we're all aware of that.
And I'll second that.
Okay. It's been moved and seconded. Let me recognize Mr. Little if he wishes to speak on his motion. Okay, anyone to wish to speak on this motion? Any citizen wish to speak on the motion?
I'll
I'm
just
sorry,
briefly
Mr. Wood.
say that if you go through the process that you go through with citizens' initiative petitions, again, it is a long process and a lot of work. What you don't want to have to do is after 1 year, the county commission overturn that. And I was in favor of it being a majority to overturn this after 5 years, but I will settle for a supermajority.
You mean a unanimous vote?
A unanimous.
Right.
Sorry, a unanimous.
That's what
All
we had
five,
initially,
yes.
but, right.
And instead, I can settle for a supermajority.
Okay. Further questions, further comments? The only comment that if no one's, oh, I'm sorry, Mr. Barnes.
I'll have to figure out how I'm going to vote on it, but I'm curious that we're, on the one hand, we're saying trust, but on the other hand, this seems to hamper the county commission, and you're basically saying that you don't trust them to keep your initiative going forward. It's just, to me, it's the dichotomies and the ironies in everything, and I'm sure there's plenty of them in my own opinion, but they are perplexing, as someone said it. But I'll probably support it. Thank you.
Thank you very much. Seeing no other hands, the only just sort of a conforming thing in the ballot language, it says repealed by the Board of County Commissioners by an affirmative vote of at least 4 of the 5 commissioners, but in the resolution, it doesn't have an affirmative vote. Sarah, does that need to be in there? Okay. Without objection, then can we agree that that she can
Yes.
repair that? Okay. All right. Great. All right. Well, then the motion on the floor before us. Any citizens? I didn't say yes, ma'am. Ms. Delaney, Commissioner Delaney. Okay.
Let me see. Rather than necessarily saying 4 of 5, unless you want to come back and deal with this language, a supermajority, I believe, implies that. And if for some reason we had a different number of people in the future, I don't know if you want to tie it down to just a supermajority, I think, implies what this is. I don't know if you want to have the numbers. I'll leave that up to people who know more than I do.
Okay. All right.
That seems to make sense to me, since apparently.
Does it make an amendment?
Mr. Chair, I move that we strike the language that refers specifically 4 or 5 and replace it with simply supermajority.
Second.
It's been moved. Then we replace 4 of the 5 county commissioners with a supermajority of the county commissioners.
Mr. Chairman, could I ask a question of our attorney?
You may.
Did you agree with that statement? And you don't have to say yes or no. You can expand on it.
She must feel great that you got a lot of work.
Having drafted a local option sales tax that used this term supermajority and fielding all the questions that I got about what that meant, I would prefer to have a number in there. And if we should, if a future charter amendment should say, let's go to 30 commissioners or some number around there or less than there, you could just have a conforming amendment that would then calculate what that meant.
When you say a conforming amendment, would it be part of this ballot language, or would it have to go back to a charter amendment later again?
If you go, well, right now you've got 5 county commissioners. So it's real clear what 4 out of 5 means, an affirmative vote. If you go from 5 county commissioners to 7 county commissioners, what is a supermajority vote?
5.
5 or 6.
4. I mean, I really don't know what that means.
Okay.
Or maybe to say a majority plus 1 would be a better phrase, a majority plus 1.
No, I don't like that.
Mr. Chairman. Mr. Little.
With the proposed language here, it's possible that 3 members of the county commission could overturn the ordinance, because you may have a situation when only 4 are present, that's a quorum, the supermajority is 3. So I think this should be defeated.
Okay.
The matter that was brought up by Commissioner Delaney can be handled. If there is a charter commission to change the number of county commissioners, then this language, as our attorney said, can be changed as a part of that change.
Mr. Chair.
I withdraw my second.
Hold on, let me.
Well, you can defer. I defer to you. Not that I'm flighty, but I was convinced. But go ahead.
All right, so you're withdrawing the motion, Mr.
Yeah, I'm withdrawing the motion.
Okay, well, without objection, we'll show the motion's withdrawn.
Let the record show that a non-lawyer brought that question up.
Who played one on TV?
I tell you, that's great. All right, any further discussion? Then we're back on the motion. Back on the motion. Seeing none, I think we're ready to vote. Greg, if you'll call the vote and announce the. I've asked for it twice, but if there's any citizen who wishes to comment, okay.
Mr.
Greg.
Ackerman?
Yes.
Mr. Brinkman?
Yes.
Ms. Ferguson? Mr. Glazer? Mr. Grundy?
Yes.
Mr. Irby?
Yes.
Mr. Little?
Yes.
Mr. Abronsi Martin?
Yes.
Mr. John Martin?
Yes.
Mr. Richards?
Yes.
Mr. Tuttle? Yes. Ms. Martin? Mr. Wood? Yes. Mr. York? Yes. 12 to 14.
12 to 2.
14, wow.
12 to 2.
Mr. Chairman.
You may be may make county manager, but you're not going to make supervisor of elections. I can tell you.
You make a good budget man.
Mr. Chairman.
I'd already said I recognize Mr.
Yeah.
Grundy.
Somebody else.
Oh, I'm sorry.
I'd already said I'd recognize.
Oh, Mr. Grundy. Okay. So,
Thank you, though.
Mr. Chair, I'd like to move forward question number 4 for consideration.
There you go.
what's number 4? Well,
The
This
Charter
is the-
Commissions.
Charter Commission is it? And I
It's
think
the-
as all the members are well aware, this opens up the gate for
You said we were going in
pretty
order,
much
so
the
I'm just
remaining.
following
I
what-
understand.
yeah, but
I understand.
can we speak to that? Would that be in order to speak to that?
It hadn't been seconded yet that I've heard.
I'll second it.
Okay, been moved and seconded that we take up question 4.
Can we speak to it?
Moved and seconded. Let me recognize Mr. Grundy since he
Oh,
made the
I don't
motion
need to
first.
speak to it.
Okay,
No, no.
no motion, no to speak. Okay, then I recognize Mr. Martin.
This is a motion which kind of a lot of things have been log rolled into, including now that there's some question about removing the language or adding the language of requiring that certain single member districts be out. 3 no longer won't go out to the county line. Should be logged in, rolled into this. The lateness of the hour, the lack of public here at the moment to comment on this after we make a motion. I don't think it would be appropriate at this time to discuss this larger issue, particularly in light of that we don't have the number of public participants here to comment as we agreed would be appropriate after every action.
Okay. If you motion, if you'd wish to move to postpone it to the next meeting, that's certainly in order. It's up to you.
I move to postpone this to the next meeting.
It's been moved and that we postpone this question until the meeting on the 23rd.
Is that a motion to put it on the table?
Yes, that's
Yes.
a motion to table.
No, it's not a motion to table. It's a motion to postpone it until the next meeting.
Oh,
That's a different motion.
Yeah.
it is?
It is.
Yeah, and this motion is debatable if you want to debate it.
Oh, okay.
I actually will.
Okay, Mr. Grundy?
John was before me. John was before.
All right, Mr. Martin?
I concur exactly what Mr. Martin said. I would just add to it that maybe a friendly amendment, if they would accept it, that we postpone all the rest of these votes until not just this one, but go ahead and for the very reasons that Mr. Martin said.
I'm fine with that.
If the seconder.
It's been moved then and amended that we amend the motion to postpone.
No, I asked for a friendly, so if the motioner says yes and the seconder says yes, it's done, right?
Yeah,
No.
I'm friendly.
We have to vote on the motion.
Vote on it.
All right, without objection, then as I understand it, then Mr. Martin's motion then is that we postpone the remainder of the questions until the 23rd. Am I correct on that, Mr. Martin?
Yes.
Okay, that's,
Mr. Chair.
and the second agrees to that? Second agreed to that? Okay. Been moved and seconded then. Is there any further debate?
Yes, Mr. Chair.
Yes, sir. Mr.
Okay.
Brinkman.
While I realize the hour is late, I am quite sure we will be here equally late at the next meeting because, in addition to the usual orders of business, we also have a guest speaker presentation coming in, and we are frankly leaving the majority of the work on the table if we leave now. I think I've made no secret of the fact that I oppose the whole Charter Commission concept. I intend to vote against it now or at the next meeting. But, take your pleasure. We could well end up here very late in the night unless we want to schedule yet another meeting. And I believe, and I would like staff's, what is our drop dead date for completing our work for the benefit of the supervisor so that things can make the ballot? Okay. And staff typically needs a couple weeks for that. So
the next
Certainly, our plan is to finish on the 23rd.
So the staff is saying, just for the benefit of everybody, so it's on the record, that July 13th it has to go to the county commission, and Commissioner Delaney tells me that that's the only meeting they have in July. So it sounds to me like we pretty much will have to finish our work this month. So if it's not going to be on the 23rd, it's going to have to be pretty soon thereafter. I just want to caution everybody, because this is summertime, and I know not everybody might be able to make all the meetings. So I would urge that we keep on working.
Well, I'm sorry, Mr. Andy, but the point of the motion, I'm sorry, making was not to. It's not about the lateness of the hour. It's the fact that that we don't have a large amount of public here to comment on. So no, we can work late, but that's not really the issue at all.
But what concerns me is, and we say this, but this is again a proper a function of protocol and how we're doing the meetings again and how they're flowing. So I mean, it's sort of the double-edged sword. Granted, we've lost participation, but we really again need to get our work done. And I would urge you to vote against this motion, this amendment.
Mr. Chairman,
Mr. Little.
I urge a vote against this motion. This matter was on the agenda for tonight. The public was here. The public wasn't interested in this. They were interested in something else. They've gone. The people that are interested are here. So let's do our business and get it done. It's not going to change the vote on any of these things.
No.
All right. Mr. Martin.
Thank you, Mr. Chair. I would only make one comment about that. I think we've all agreed, at least I think, based on what we've said earlier, that we're going to postpone the vote on the single-member districts until the next meeting.
That was the only one.
But there was a question within the single-member districts that we're supposed to be being educated on by not only our attorney, which she did a good job earlier, and the person that's going to be speaking to us as to how that ballot should be if it's independent. We've heard one opinion of our attorney that if it were drawn to the county line, it would have to be tied in to this particular motion. And if it were standalone, it would have to have that language out. I think if it does a grave disservice to sit here and say that you want more education before you're going to cast that vote, and now in my view, and I haven't made it personal, for political reasons, you want to cast votes now when you're going against the very thing you've been saying, which is the one time we're talking about having research that would affect an issue, we're going to flip it around and say, okay, we're going to take an up or down vote on something that could directly impact the presentation and the vote on the coming issue. So that's my issue. You know me. I'll stay here all night. That's not my issue.
Mr. Martin, single-member districts does not involve the Charter Commission. It does not require that, so it's not going to affect it.
It does if we heard our attorney. I correct you, sir. Our attorney, and she could speak to it herself, said earlier that in her view, if you use the language as it currently is, that is no more than 3 to the county line, it would have to be tied in to this proposal. She said that verbatim right here.
Yeah, well, that's correct.
Do that next week, Mr. Chairman.
All right. So if you vote on that right now and kill it, then it takes that option out, which is what that's all. I'm not about. I mean, I don't care. I'll stay here all night. That's not it. That's not my view. I'm just simply saying, don't on one hand say you want education and then flip it the other. I'm only asking for consistency.
It just appears to me, what really concerns me is we're always, and when it gets late, we're always ready to get out of here quick. All of us got jobs. I mean, we're always ready to get out of here. We need to really do the people's work and get it done now. We agreed at the beginning of this meeting, the only thing that we were going to postpone was single-member districts, and that's why I'm saying, let's go forward with that. That's the only thing that we all agreed to by unanimous consent, pretty much, and voted and agreed to.
All right. I think we're ready to.
Could I just so I want to hear from our attorney. I just want everybody to be clear. I'm sorry, but I think we need to be clear on this. If we vote tonight to not support this particular issue, number 4, then the only way that single-member districts would be legal is if it were that language of not to the county line were taken out. Is that correct?
That was what I said.
So
yes.
understand that you're circumventing, I just want to make it clear, you're circumventing what you said, which was more education on that particular issue. You are limiting the discussion on that issue by taking action on this one. And I think to not realize that is disingenuous.
All right. The motion before us then is to postpone the remaining questions until the meeting of the 23rd. Any citizen wish to comment on this? Please, sir. You've been most kind to sit with us all night.
Yeah,
Welcome.
I'm Robert Wilford, and I'm a recently elected city commissioner from Alachua. And I agree with all the comments on most part, but, you know, it was stated at the beginning of the meeting that if you want to speak to an issue, you could stick around and speak to those issues. I disagree with the last comment because I think that last issue, if you had to change the language later on to affect whether 4 is passed or not passed, you would have that opportunity at the next meeting to do that. And you did vote on this meeting that you're only going to table one issue. And I have sat here all night, and I was in a meeting with Commissioner Delaney today. I have a full-time job as the CEO of an organization, plus I'm a city commissioner. I'm darn busy, too. But I think you need to complete your business. I think if you complete your business tonight, then in essence, now if you stay to 2 o'clock in the morning, I may be gone about 12:30. But the bottom line is, I think you can react to all these other issues on there, and then that last issue, if that needs to be amended to meet his concerns, the commissioner just had those concerns, that could be amended, I think, and I don't know if the attorney agrees that or not, but if then, in essence, we talked about single-member districts for a long time tonight, and whether I was for or against that, I didn't make that known since I am a new commissioner, and I'm not representing my commission tonight, I'm representing myself. So I think you need to complete your business. I agree with the idea that you have enough information. If you're going to go back and research all these articles, then you'll never get your business completed by June 30th. So that if you didn't do the evaluation, I don't disagree with Commissioner Little, but if you did do the evaluation already, it's a little bit late in the game to go back and say, now we need to evaluate every issue that's on there. So I think you need to conduct your business. Those of us that stuck around are willing to listen to what you got. And I may make a comment. I had to run in a nonpartisan election, or by the Hatch Act, I could not have run. So I certainly might have a comment to make about nonpartisan elections since it affected me directly. So thank you very much.
We appreciate it, and congratulations on your recent election there in Alachua. All right, I think then we're ready to vote on the motion to postpone then. Motion to postpone is before us. Greg, if you'll call the roll again. I'll give you one more chance here. This is only on the motion to postpone the remaining items until the 23rd.
All right, Mr. Ackerman?
No.
Mr. Brinkman?
No.
Ms. Ferguson?
Yes.
Mr. Glazer?
Yes.
Mr. Grundy? No. Mr. Irby?
No.
Mr. Little?
Yes.
Mr. Abronsi Martin?
Yes.
Oh, I'm sorry. Let me mine is a no. I was jumping ahead to something.
I thought I was confused there for a minute.
We're all getting tired, so let's just plow through.
Carry on. We corrected Mr. Little's vote. All right.
Mr. Abronsi?
It's your motion.
Yeah. Yes to postpone.
Mr. John Martin?
Yes.
Thank you for looking over.
Mr. Richards?
No.
Mr. Tuttle? Yes. Ms. Martin?
Yes.
Mr. Wood?
No.
Mr. York?
What is it?
Okay.
Oh, okay. 6 yeses? 7 noes.
Ooh.
Missed somebody.
Wait, did you say postpone?
Mr.
Yes, yes.
7 to 7.
Motion fails.
Motion failed. Let's go.
All right. Then we will return to Mr. Grundy's motion, which is item number 4, which is again replacing the Board of County Commissioners with a Board of County Charter Commissioners. As revised that you provided us today. That's right.
Correct.
That's right.
And I have a point of information, Mr. Chair.
I recognize you first. Motion.
Mr. Chair, this is also the ones that are interrelated, correct? This question and the other question? Okay.
That's correct. This is the gateway.
I'm not going to speak. I just wanted to have an up or down vote on it, so I'm not speaking.
Okay.
Mr. Chair,
Mr. Brinkman.
I did not receive any emails today from staff, so I would ask that the attorney cover the specific revisions that were sent out today.
Okay. I think it's in your packet there also that you got in front of you.
Do you have a hard copy of it?
No, but I've got a hard copy of the June 8th version, yesterday's
Right.
version.
Okay. Let me see if there's one in here.
I'm looking at it, rather.
So you awake?
Well, the hard copy you handed out has it in there, right?
Right.
Okay.
This question is the structural change to replace the Board of County Commissioners with a Board of Charter Commissioners. And the revisions that I made what were they? Let me look at my notes.
I think you just got rid of the word abolish in that one.
Abolish?
You got rid of the word abolish, right?
Abolish, yes, that's right. And I reworded it so that it would make sense when I got rid of that word. Thank you.
Here's some coffee.
Yeah.
That's it.
Does that answer your question?
Well, actually, though, but, I mean, in the title here of the hard copy you just handed me, you're still using the word abolish.
They haven't used the word.
No, look at the next.
Look at revised.
Revised, you have.
Okay, there's question 4 and there's question 4 revised?
Yes, it's got that
Okay.
rev in the front.
Right. Still not finding it.
It uses the word
Anyway,
replacing.
so- Right.
Replacing the Board of County Commissioners as the governing body of the county with a Board of Charter Commissioners. Transferring all the powers, duties, and functions of the board to the Board of Charter Commissioners. We delete some obsolete provisions. Those are on page 2 of the resolution, and those provisions, let me point them out because the chairman had a question about that earlier. That's a residency requirement. That residency requirement has been found unconstitutional, as I understand it, although I wasn't here then,
For county commission.
for county commissioners. So we're deleting it because we did, because it was ruled unconstitutional. It may not be now if we've got charter commissioners, but that's what it does.
Okay.
Ms. Blakely,
Mr. Grundy.
So we revised and using the word replace. I mean, I know we went back for this tit for tat again with between the word abolish and replace. I mean, why are we leaving out the word abolish?
The reason we used the word abolish in this provision was because we used abolished in question 7 relating to the constitutional officers. And because we're no longer using that there, it's such a harsh word, I believe, as somebody called it. I think the word replace more accurately describes what we're doing.
Okay. Thank you very much.
I have a question.
Mr. Glazer.
Thank you very much. I have a question as it relates to the residency requirement. There's language here that is struck, but we're talking about making it a charter commission, correct?
Correct.
And in reading your memo to me, if I understand it correctly, you could address residency requirements within these changes. Is that correct?
Correct.
Okay.
You could have a reasonable residency requirement.
Okay. And explain to me why we struck the language that is there.
We were doing cleanup. It's always, as somebody who reads the law, you know, the legislature every year takes out stuff that's been ruled unconstitutional, renumbers where there's mistakes, and that's what we were doing.
In your memo, you address some ideas about residency requirements that you think might meet the threshold and be allowable constitutionally. and you refer to questions 4, 5, and 6 as being potential initiatives that this language could be placed in. Do you have a particular one that you think it would be better suited?
I think that's not a legal question.
Okay.
I mean, because what I said in that memo was that the Charter Review Commission is not limited by a single subject requirement like there are for other referendum issues.
Right.
The Charter Commission, at least it's been determined by courts in a few
And
circumstances, not limited by that. The Alachua County Charter doesn't have a single subject requirement like some other charters do.
Okay.
So it would be appropriate, and so where you place it, I think, would be more a strategic than a legal issue.
Right. And so just for clarity, if it's not, if we keep it as county commissioners, we cannot impose a residency requirement because state law precludes it.
That's correct.
Correct. So I think, in looking at this issue, that item number 4, or question number 4, as it's been posed to us, is the best place to put potential residency requirement. And I would like for folks to look at their packet, and I'm going to read.
Give us page number 2.
I'm sorry. It's a page 1. It's it's towards the very back, and it might be on the back page of.
It's in the revisions, right?
Yes, it is.
Thank you.
Did you find it?
No.
Okay.
Is it page 56, residency requirement?
It's an individual memo. That's it, DJ. Yes, it is. The third paragraph from the bottom basically states that all commissioners be electors and residents of the county for 2 years immediately preceding the date on which they qualify to run for office. Additionally, the 5 members elected from districts, we have districts in Alachua County, shall have resided within the district from which they are elected for at least 6 months prior to the date on which they qualify to run for office, which is similar language to the city of Gainesville's. Any such council member who shall move residency from the district which elected shall thereupon become disqualified to represent the district as a council member, and the office of the commissioner shall be deemed vacant. I think, and I would like to move that we add this language to item 4 and have you appropriately place it, I believe would be under subsection A, what has been struck. This, to me, kind of drives at the heart of what Professor Little was saying is about improving county government. I think this drives right to the citizens getting representation, even if we do single-member districts or not, just under a district plan that says you will reside within that district 6 months prior to running for that particular office.
Let me see if I've got a second on this.
Okay.
Do I have a second to his motion?
Second.
It's been moved and seconded, and now you're welcome to debate.
It again goes back to the heart of citizen representation from the district plan that we currently have, even if the single-member districts change of, I believe, number 8 would be implemented. And the city of Gainesville has this. I think it works very well. I think the 2-year residency requirement for Alachua County for somebody to come into this community and run for county commission is something that makes sense. And I think somebody living within a district for 6 months prior to qualifying makes sense. And so we've talked about this many meetings ago, and looking at the city of Gainesville's language and kind of dovetailing that that style that seems to work, I think is a very good addition to this item. And I'll just close with that. Thank you very much, Mr. Chair.
Thank you, sir. Mr.
All right. Regarding the City of Gainesville residency requirement, it is in their ordinances, or the charter rather, but in point of fact, based on my understanding, their attorney has advised them that they cannot enforce it because of the federal constitutional restrictions on this. In fact, it is my understanding that the federal courts have held that anything more than 30 days is unconstitutional because it inhibits a person's right to move to a different community and participate in that community. Now, that's actually for voting, but I would suggest to you that if you can vote in an election, you ought to be able to run as a candidate in that election. And frankly, a 2-year residency requirement would tend to prohibit a lot of people who move to this community from being able to vote. And I would remind you, a lot of people move into this community on a regular basis because of the universities we have here. I don't support a residency requirement at all. In fact, some states have actually moved to same-day registration. You can actually register to vote in that state on the day of an election and vote on that day. I really, this kind of reminds me of the way that a lot of candidates like to talk about how they're lifelong residents, as if that is a qualification for voting, for running for office. Because frankly, I don't think you have to be a lifelong resident. I don't think it takes that long to get up to speed on a community if you're really interested in it. And I don't see any need to restrict residency.
Okay, thank you very much.
Mr. Chair.
Let me recommend Mr. Grundy, and I'll come right to you, Bill. Okay, Bill, go right ahead.
You're on, Bill.
Go ahead, Bill.
I am against this proposal for different reasons than Mr. Brinkman. We've been looking at this, which we initially referred to affectionately as the little plan or the little compact. This is the thing that will change everything else. At this late date, and we haven't talked about this, we're getting ready to vote up or down to add a cumbersome new topic onto the question, I think is bad form at this point, and I would not support it.
Appreciate it very much.
Mr. Chair.
Yes, sir.
I don't support it either, and mine's a more pragmatic reason. If you have a good candidate, you have a good candidate. If you have a bad candidate, if it's a true carpetbagger, they're not going to get elected. It just strikes me that we're busy fixing things that aren't really going to be, in reality, a true problem.
Okay. Further comments?
I would ask, excuse me.
Go right ahead, Rod.
I'd ask our attorney for the legal, we're both talking opinion and legal opinions. We're both talking opinion and legal opinion. What is your opinion to this residency requirement?
Well, there are two issues. One is what the Constitution of Florida says, and the other is what the federal Constitution says. I didn't have much time today to research the full federal law, but it's my understanding that a reasonable residency requirement would be okay. Whether 2 years, like the Volusia County example that I gave you, meets that, I don't know. I just couldn't opine without doing some further research.
But you believe 6 months is reasonable?
Probably. Voting is certainly a different matter.
The current charter, just so you know, says each candidate for the office of county commissioner shall reside within the district from which such candidate seeks election at the time of qualifying to run for that office, and then goes on with the same language that during the term of office they'll continue to reside there. That's what the current charter says. Other comments? Yeah, the proposal, however, knocks that out.
Go ahead, Mr. Martin.
Well, it seems to me by what Ms. Blake has indicated that, as I've always stated, there are a number of factors that's going to come to play. So even if we pass this, even if we decide to move this forward, that there's going to be something that the United States Constitution might come and say, you know what, it just don't count anyway. And I think that's true of so many things that we're pushing forward, that it just might not matter anyway, and we're not, regardless of whether or not it's a good idea or not, which we haven't put a whole lot of thought in that either. So,
Mr. Chair, in regards to Commissioner Tuttle's comment about a 6-month residency requirement, I can cite a specific instance in the city of Gainesville. In 2004, a young student named Michael Bell ran for mayor against Begin Hanrahan and one other candidate whose name escapes me at the moment, C.B. Daniels. But in point of fact, the question was raised about whether or not he was a duly qualified candidate because he had not lived here for 6 months. And that at that time, the city attorney advised them that he did not believe they could enforce their 6-month residency requirement, and they have not made any attempt to enforce their 6-month residency requirement since then. So I would hold that 6 months is an unreasonable residency requirement based on precedent.
Okay. I recognize you, Mr. Grundy.
Yeah, but as someone who's run for office, they haven't enforced it, but I do know for a fact that the supervisor elections will enforce that. And even candidates still currently, within regards to the city, not necessarily the county, but within the city. The supervisor elections, you had to sign an affidavit, which if you falsify that document, that's criminal in and of itself as well.
Mr. Bell was a candidate for mayor of the city of Gainesville, and the supervisor of elections did not enforce it at that time. Now, I frankly can't remember whether that was Bev Hill or he did eventually, but he was allowed to run. He was on the ballot.
Okay, I can't speak to that part. I just.
All right. Mr. Glazer.
I would like to change my motion if it's,
Offer a substitute.
yeah,
motion.
offer a substitute motion that would eliminate the first sentence of the portion that deals with the 2 years immediately preceding the date in which they qualify to run, they must be residents. To make it just the 6 months is the
6 months
infamous.
prior to qualifying.
Correct.
Is there a second on his substitute motion? Been moved and seconded, and then that, now the motion before you will be that basically each candidate for the office of Charter Commissioner shall reside within the district from which such candidate seeks election at least 6 months prior to the time, prior to the time of qualifying to run for that office. Did I state that
Correct.
correctly? Okay. All right. Comments on substitute motion? Mr. Martin.
Thank you, Mr. Chairman. To me, it sounds reasonable based on what our attorney was saying is you know, that the law says about reasonable. I do respect what Mr. Brinkman said. I'm not challenging the facts of that because, quite frankly, I don't know the facts on that particular case. But it does sound like a reasonable requirement, so I support it. I would just ask something that I don't think will be. I certainly can't hold anybody to, and I don't think will be adhered to. But I keep hearing members continuously say, and not necessarily on this issue, but we have not researched this, we have not looked into this, we have not given this proper thought. And on this issue, you might be right because it just came up, but I would respectively ask you to say, I have not researched this issue, I have not given this thought, because you are implying that others of us have not researched it, have not given it thought. If you wish to make a statement that you have not given it research, then that's valid. But to imply that members of this board, I mean, I don't think anyone, for instance, would say that Mr. Little has not researched these issues. But when you say we, you're implying that he hasn't researched any of these issues.
I can take
All right.
So I'm just saying, I think it does a disservice to continuously say we, when in fact what you mean is you.
All right.
Thank you.
I'll remind everybody of Bill Sadowski's thoughts today that I read to you earlier on. Let's stick with the program here and not question anybody's motives or anything else.
What I've been saying all
I understand that. I understand.
Yeah, okay.
Well,
We're just
may I-
reiterating that. Council.
If you all want to move forward with this, I would suggest that I do the research either on the 6 months under federal law, whether you pass it tonight or wait and do it at a later point. I think that. Okay.
Yes, please.
We'll decide this in the courtroom if needed be, right? All right.
Mr. Little.
All right. The motion then before you is a substitute motion that, as far as on question 4, that we add the language back in there, along with some additional language, that each candidate for the office of Charter Commissioner shall reside within the district from which such candidate seeks election at least for a period of time, at least 6 months. I'll let her wordsmith that, 6 months prior to qualifying to run for that office.
We're voting on the amendment,
Correct.
not on the motion.
On the substitute amendment, that's correct, substitute amendment.
Or
That's
just the
right.
amendment?
The amendment is where it is, that's right. All right. Anyone in the audience wish to talk about this? Please.
I have not had time to research this either. But I think overall, when you're talking about, again, somebody doing the representation for a group of people, I would clearly think that they would have resided in that area for at least 6 months. So 2 years is probably not a bad idea, but at least 6 months. Put some type of precedent in there so that they have that vested interest in having lived in that community for a while so that they can represent it properly. Thank you. Oh, I'm Susan Baird.
Thank you very much, Susan. Thank you so much.
Sometimes they like that.
All right. Any other comments? Okay, counsel?
About this issue. So we're just adding that one basic concept and not the disqualification if you move out, right?
No, that's already in there. That's already in there.
Okay. Okay, so that's the original motion. Now we got to say, okay.
Right,
Okay.
that's all in the original part. We're just adding the part that was previously stricken, each candidate for office, you with me there? And then adding in the 6 months as part of that. Okay? All right. Since this amendment, let's just see if we can get, let's just see if we can do it by voice vote real quick first, see how we come out. Those in favor of adding that amendment back into this proposal, say aye. Aye. Those opposed, no?
No.
Come up, Greg. All right, call the roll. This is on the amendment.
Mr. Ackerman.
No.
Mr. Brinkman.
No.
Ms. Ferguson. Mr. Glazer. Mr. Grundy.
No.
Mr. Irby.
Yes.
Mr. Little.
No.
Mr. Abronsi Martin.
No.
Mr. John Martin.
Yes.
Mr. Richards.
No.
Mr. Tuttle.
Yes.
Ms. Martin.
Yes.
Mr. Wood.
No.
Mr. York. 6 yeses, 8 noes.
By your votes in, the amendment fails, so we're back on the original question 4 as provided to us by the attorney, Mr. Grundy.
I actually want to ask a question of my colleagues and get your thoughts on this regarding this motion. Even though I brought it forward, I want to bring it forward for an up or down vote. But the other question, the first two questions I have, one is, does this initiative that we're putting forward on the ballot improve county government? That's first. The second one is this change really needed to change county government? And the question is, why? And I welcome any of your thoughts. Those two questions I want to hear my colleagues' thoughts on.
Mr. Brinkman.
Thank you for the invitation, Commissioner Grundy. I do not feel it improves county government in the least, with all apologies to Commissioner Little, and I don't think it's at all necessary or will benefit the county. So that's why I have always opposed it.
All right, Mr. Martin.
Thank you, Mr. Chairman. And I hope, because if my understanding is correct, if we vote this down, there's no reason to discuss the other issues that are connected. Is that correct?
That's going to be correct.
So if we have issues with the others, we need to, I just want to make that clear, we need to discuss them now. So I want to make a couple of points in case it gets voted down the other way. Okay.
And the only one that's outstanding on that is the single-member district,
Right.
which can
So
stand
this,
on its
this
own.
one, so you need to be able to discuss each one of these at the same time. And
This is the gateway motion.
okay. First of all, I think that this particular proposal goes to the issue of home rule. And although I'm not saying that, and I've continuously said that I hope we won't look at the current county commission and make decisions yes or no based on that, because that's not what this is about. We've already had plenty of evidence that there are very few commissioners that serve more than 2 terms. That's one of the reasons why we killed the term limit issue. So whatever comes here is not going to affect necessarily this current commission, but it's going to be in effect, unless it's overturned or changed, for at least another 10 years when the next charter review. So it's not a popularity decision on the current county commission. And I think that we do a disservice to those that appointed us if we make it about the current county commission, because none of these issues should be, our votes, in my view, certainly mine has not been, based in any way, shape, or form on the current county commission. With that said, I think this increases home rule. I will give you several evidences as to why I think this is important, because it ties in with these other issues. First, with the salaries. My father was the one in the state legislature that pushed forward tying this issue, so I think I can speak with some authority on this, to tie county commissioner salaries to state law. He was the one that pushed it forward. At the time, the reasoning was because county commissioners in very rural counties were making less than $18,000 a year. Now, somebody mentioned earlier about the law of unintended consequences. I don't think at the time that my father was pushing that, he ever envisioned that a county commissioner will be making upwards of $80,000, and in the not-too-distant future, it'll be $100,000 a year. I'm not necessarily saying they don't deserve that, but make no mistake that when you put these clauses in there that are tied to cost of living issues and population, when you raise someone's salary 3% when they're making $20,000, it's not that much money. But when they're making $80,000, it begins to go up, and so the longer this stays in effect, the salaries are going to escalate even more as a multiplying factor on there. Okay, what this does is enable what every other elected body besides county commissioners have to do, which is set their own salary. Every other body I'm aware of has to set their own salary. What makes our county commissioners or any county commissioners, God Almighty, that they don't have to set their own salary? Can you imagine how different their votes might be on issues had they, and I'm not talking about the current county commission, what might be if they had to set their own salaries and they had to look at that. They can vote on cutting an employee's salary, but they can't even vote on cutting their own. I think it's inherently unfair and an unintended consequence that has happened. And as I say, my father was the one that pushed this through, but I think he was trying to address a weak salary structure at the time, and the unintended consequences is the multiplier. So that is one of these. You want specific evidence? In my view, that's specific evidence as to why this is needed, because under the current charter, the county can sit back and say, I didn't have anything to do with that. So it puts more responsibility on the current and future county commissions, and it puts more home rule. It's a direct home rule issue. So that's why I'm in favor of it for the salaries. Now, on the nonpartisan election, I've made it very clear that I've been a lifelong Democrat, come from a long-time Democrat. I realize that if you go to nonpartisan, there's a very good chance, possibly, that it might hurt the power structure of the Democratic Party in this county. I'm aware of that. You know, I'll probably be chastised roundly for that by some fellow. I've voted mostly mostly, Freudian slip. I've voted mostly, and you can laugh if you want, I've voted Democratic my whole life. Anyone who doesn't believe that, look at who I've donated money to, what I've done. I don't donate money to people that I don't support, okay? I have voted that way and probably will continue to vote that way. There's two main reasons why I think we should move to nonpartisan elections, and they're very concrete. One of them is the rise in this county and this country of independent voters. It's one of the fastest voting blocks coming out there, and this disenfranchises them. You can say, yes, they get to vote in November, but they don't get to really select who that choice will be. They are stuck with the choices of two parties that they have no say over. Okay? Now, the state tried to address this. The state tried to address this across the board by having open primaries. They tried to do it, and both the Republican Party and the Democratic Party, to their advantage, in the areas where they've controlled, have usurped this law with write-in candidates who have no intention whatsoever of running. Everybody here, if you follow politics, knows that is a fact. And in my view, it circumvents the letter and the spirit of the law that the state legislature passed. Now, for whatever reason, they have not had the courage or the will to go back and address that issue. If we had open primaries that would allow people to vote for the candidates of their choice, I would have no problem saying I don't support the nonpartisan issue. And I agree 100% with those people who have said that there's always going to be partisanship. Certainly there is. I don't think, at least me, I'm not trying to eliminate partisanship in a sense that there's going to be people who are identified with Democratic parties and Republicans and whatnot. What I'm trying to do is give access to those people who have voiced that they want to participate in this process. The state legislature, as I reiterate, passed this. In my view, we have a duty to open this process up in spirit with what the state law says, which was their intent to open these primaries up to all voters. We've heard eloquently about people saying that single-member districts restrict people's right to vote. I've heard many people wax and wane here about giving people more rights to vote. You sat here, we just passed two charter amendments to try to gain more access to people so it makes it easier for them. Yet on this issue, we want to completely write out a growing segment of our population simply because we have particular party issues. I, for one, am willing to stand up here and say I have the courage, even though it might even hurt me personally, to say that it is not right. It is not right, and it will absolutely, in my view, improve county government if you allow everyone to make the initial choice for who they choose in November in the primaries, and it will go back to the spirit of the law that the legislature passed and the people unanimously, I think not unanimously, but overwhelmingly have supported. It's political parties that have circumvented this. In Alachua County, and I'll say this and I'll pass, Alachua County, it's been the Democrats. In other counties, you'll hear the Democrats crying foul because Republicans are doing it to hold their power in certain counties. What I'm saying is disarm both of them, open it up, return the power to the people, and let them decide. And because there's no other way to do this, and the fact that the legislature has been circumvented, then to me, the reason to support this issue about the replacement of the county commissioner charter is to open up the process for more people. I would ask you, and I would ask fellow Democrats, Republicans, and everybody else out there as a politician say, within the sound of my voice, what are you afraid of? What are you afraid of that you won't open the process to as many people as possible? Now, you've challenged me to present some evidence. I challenge you just as well to tell me what you think would happen if you open this up and how that would make county government worse. In my view, nonpartisan would make it better. Now you tell me how keeping it the status quo, not keeping the powers that be, but will improve county government, like has been said. You tell me how you think writing off roughly 30, 40,000 people that cannot vote, how that improves county government. Thank you.
Hey, Mr. Martin. Mr. Martin on this. I got it. You're like,
No.
still good? Okay.
Yeah, there's no.
All right. Mr. Little.
I'd like to respond very briefly to Mr. Brinkman's question.
Actually, it was Mr. Gunn.
No, it was Mr. Brinkman's question. Is this necessary? No, it is not necessary. Will it improve county government? It will improve county government in the same way that adopting the charter did. It will give us more flexibility in terms of reorganizing the government in the future if we decide to do so. So I think that the same argument that supported adopting the charter, and it's really more home rule, is the basis for doing this. It's not necessary.
Thank you very much. Mr. Glazer asked me. I'm sorry, I'll come down here. He mentioned it. Okay.
I actually, Mrs. Elrad gave a list of names to us tonight, and I've seen this list before, and it's 1,056 people who voted in the mayor's race in Gainesville on March 16th. And this is the Green Party, this is the Independents, this is the no party affiliation. These are the individuals that would have been precluded from voting in the mayor's race in the primary. So if you want evidence about people having a greater participation in the election process, and you want the facts, this is the facts. These are the individuals that went to the poll on that specific day to cast their vote for their choice of mayor. And they would have been precluded from that participation. So if you ask the question if nonpartisan would engage more voters, the proof is in the pudding. It is here, it is factual, and it's out there, it's public information. And that's what, unfortunately, she did not articulate her position very well, but that is the real world. And so to the heart of nonpartisan and what you're talking about, opening up this process or having open primaries, this is exactly the folks that you're actually carving out of the process. And it just doesn't make sense to have the philosophy that we're one person, one vote, but that's only if you have a certain belief system that's similar to mine. And so nonpartisan will engage a larger number of the citizens in this community, and it's 1,056 just in the city of Gainesville, and you hear all the numbers about how many are in the county versus the city of Gainesville, and so it would only lead you to believe that that number would be at least twice that many. And so I would strongly encourage us to move. It does incorporate better government because it allows us the home rule options of saying this is how we want our system to work. And we, as the citizens looking at the ballot language, can make those determinations ourselves to say that this will work better and this is the system we want to embrace. So, if you pull the list, you'll see how many people would have been precluded. And I strongly encourage us to move item number 4. Thank you.
Thank you very much. Ms. Ferguson, did you want to be directed? He wants to go last. I'll take this side and I'll work back that side in a minute. Okay.
Okay, Mr. Chair. This is one of those issues that I've been kind of struggling with since Professor Little suggested it months and months ago. Because I see some value in this, especially when I consider the number of citizens who submitted suggestions in terms of recommendations that they wanted us to consider in relation to term limits, in relation to doing something with the salary of county commissioners, with nonpartisan election. So for me, I'm still struggling in terms of whether this is something that we really do need to place on the ballot. Will it make county government better? I don't know. But I do know that it probably will provide citizens with the flexibility to do more with their county government than they currently have available to them, the way the charter is written currently today. So, again, I'm not sure. I'm still struggling whether I'm going to finally support this or not, because I really don't think that it may improve county government. But I do think that citizens should have some choice in terms of if they want to limit their county commissioners, if they want to do something with their county commission salaries. Nonpartisan elections, I really don't believe that that really exists, because you can call any time and find out what party somebody's affiliated with. So that's really not a biggie to me, but it is a biggie to some people. So again, I'm just not sure how I'm going to vote on this, but I at least wanted to put that on record. That's where I am with this issue, Mr. Chair.
Thank you very much. Mr. Tuttle, did you want to be recognized? I'm coming your way next.
Nonpartisan elections is not about politics. We outnumber Democrats by 2 to 1, 52% to 27%. So it's not about Republicans sneaking into some election. Nonpartisan elections is about people. We've had dozens of people come in here and say they stopped voting. They stopped voting because they're not registered the Democratic Party. We always elect. I'm turning my back on you people.
Okay.
We always seem to elect people who are from the Democratic Party. We've been doing that for years. And so unless you're a member of the Democratic Party, you can't vote successfully for who's going to represent you. So this is really about the voters, not the candidates, not politics, but the voters should have a right. 48% of the people now have not had a right to vote for a candidate to represent them. And that's what nonpartisan elections are about. And this is a way to achieve that.
On this side, anybody wish to speak? Mr. Brinkman.
Well, to me, the effect of a nonpartisan election will be basically to eliminate election. Now, people say they don't have a right to choose the choices presented to them on the final ballot. And, I really have to question this idea that people are disenfranchised, because nobody is elected until a general election is held. You may not like the choices presented to you. You have several options. One, you can run for office yourself. If there's so many independents and they're becoming such a big power, why don't they run for office? Because I got news for you. It's really the easy way to go to run as a third-party candidate. Ask Governor Christ. You jump right to the general election ballot. You don't even have to participate in the primary. You don't have to spend any money on the primary election. You go right to the general election ballot. I have another question for you. Why should Democrats have Republicans voting to choose who the Democratic nominee should be? The simple fact of the matter is, you know, the basic idea of parties is basically found in the constitutional right to association. All of us, as citizens of the United States, have a right to associate with people whom we choose to associate with, and that includes party affiliation. And if a party chooses to affiliate and form a party and put forth candidates, fine. People can vote for those candidates if they want to, or they can vote for a Republican candidate. I mean, the fact of the matter is, the real issue I think a lot of people have is, frankly, most of the people who choose to run for office in this area are Democrats. If you don't like that, find people to run for office or run yourself. I don't really see what the real issue is to me. Let me put it to you this way. In the city of Gainesville, we've often had runoffs. But the fact of the matter is, a candidate can be elected in just one single vote, the general election day. There's no primary leading up to it. Boom. You can sweep the election and walk away right then. We don't tend to get that because we tend to get a lot of candidates running in the city of Gainesville. And I don't think that has anything to do with nonpartisan or partisan elections. It has to do with the fact that you can get on the ballot very cheaply in the city of Gainesville. It's a lot more expensive to even get on the ballot as a county commissioner. So I don't think it's going to improve things. I think the basic reason, and I'm on record as supporting nonpartisan election of the constitutional officers, because basically they form an administrative or ministerial functions. The job that Mr. Irby does, or the job that Ms. Carpenter does, is not really a policy-making job. They're there to implement the laws, rules, and regulations that already exist, and they are judged based on how good a job they do of doing that. But people who make ordinances, such as county commissioners or city commissioners, are making policy. And I think those people should be elected on a partisan basis, because I think politics does matter. That's what policy is all about. And I think people have a right to know. Under current Florida law, when you're running as a nonpartisan candidate, you are legally barred from campaigning on your party affiliation. You can't be out telling people that you're a Democrat or a Republican. They have to find out by some other manner. And finally, if you want to vote in the Democratic primary, even though I don't think Republicans should be choosing the Democratic candidate, all you got to do is pick up the phone, 374-5252, call Ms. Carpenter's office, and ask to change your party affiliation, and then you can vote in the primary. That's all it takes.
I'm impressed you knew that number. That's pretty good. Good time. All right. Further comments?
Yes, Mr. just
Martin.
very quickly. I've always said that people who have came forward on this issue have been people of goodwill. They feel passionate about that. And I heard a lot of I heard the term we should be a filter. But the request is that we filter with a number of holes in it, that we don't actually filter anything. I look at this list of names here, and it calls to mind the term of disenfranchisement. I just got to go on record here to say that throwing that word disenfranchisement around loosely, I hate to, I don't want to offend anybody, but it's a bit offensive, because this is not what disenfranchisement means, particularly in light of in November. They can go down there, these individuals, and vote for whoever's on that ballot. No one's going to arrest them. No one's going to make them take a test. No one's going to make a poll tax. So by choice, not by something that they were born with, but by choice, they chose to be an independent. We have partisan elections in this country, which serves a purpose. This is not a completely perfect world. I agree with you. The whole notion that you can have a write-in candidate who has no intention whatsoever of running is a bit offensive as well. But you don't use a bazooka to kill a fly. If you're actually concerned about that, let's address that issue. I am so concerned about what we lose in the effort to gain a little bit. Let's not lose sight of that. This is not disenfranchisement. This is a choice.
Mr. Grundy.
When I originally asked the question, and Mr. Brinkman, thank you for actually answering the question, I asked, would it improve county government? I asked, was this change really needed? And Mr. Brinkman and actually Commissioner Little answered that question. I haven't heard anybody else really answer it. I'm going to use something Commissioner Martin said, wax and wane. I've heard a lot of anecdotal and our feelings and our personal feelings on this, but again, no evidence of is this needed and is it going to change? Two things I'm going to ask. Let's go back to the past. Let's go back to 1990. We can go to 90. It's pretty current. And I'll give facts, since folks like facts, because I believe facts matter. We had nonpartisan elections in the city of Gainesville, and there are nonpartisan races. It has not increased voter turnout in nonpartisan elections. That's fact one. Fact two, has it made for a more inclusive electorate? Well, that could actually be, that's more opinion, because folks do get to vote no matter what. But it has not increased voter turnout. So then from that matter is, since those are the 90s, so bringing it to the county is that going to improve and is this change needed? I say no. And I'm actually going to steal a line from Commissioner Little. This is a motion that is going nowhere. It is not improving county government. It is not helping us. And I'm sorry I have to take your line. I like it. It's classic. I like it. And you know, it really bothers me too. I'm going to concur with Commissioner Martin Abrunsey that we use the word disenfranchisement, and I hear folks on the radio, and I'll get phone calls saying, "Oh, here go the black commissioners and the blacks complaining about racism again." You know, go back to the year 2000. I'm going to take it not an issue of race. I was in the military during that time. Whether you were a Republican or a Democrat, both sides were guilty as sin on both sides of the aisle. One side didn't want folks of color to vote. The other side didn't want military ballots to count. You want to talk about disenfranchisement, my friends? Let's talk about that. Military ballots, we don't want them to count. Why? Well, if I live in the county, my ballot should count. And that's disenfranchisement. You all want to understand disenfranchisement? Coming out of the womb and how you look, and whether it's paying a poll tax, that is disenfranchisement. Well, you're not smart enough. Or saying you may have to be a property owner in order to vote. We could set litmus tests all day long as to who can vote what. But the fact of the matter is, nonpartisan elections are not increasing voter turnout in Alachua County. They're not doing it in the city of Gainesville, and everyone on this dais has quoted that it's good for the city, it's good for the city. Well, I'm a city resident, and some of you are not in the city. Well, guess what? It has not increased voter turnout in the city. Secondly, this is not I'm going to take another line from Commissioner Little. This is not the appropriate place. This dais, this body right here, is not the appropriate place if you want to set the salaries or fix the salaries. Go to your legislature. You guys have a problem with it, go to them. Because that is who has set the bar, back and forth. Third part of this, since we're talking about, I have lost my train of thought because this is just ridiculous. We're talking about anecdotal. The bottom line of this is I'll answer the question since I raised it. It doesn't. I'm going to encourage every one of you to vote against this. It is not improving county government. Commissioner Ferguson, I know you were torn on it. It's not making county government better, and it's not needed. I urge you to vote against it. Thank you, and I close.
All right. Any comments for the commissioners?
I would just like to make one observation about the elections in the city of Gainesville. As long as I can remember, and this goes back to 1972, there have been nonpartisan elections in the city of Gainesville. So I don't think we've had a test in terms of a change in the city of Gainesville to be able to say that there was an increase in the voter turnout. And maybe, I don't know, maybe Mayor Delaney would know whether there was ever partisan elections in the city of Gainesville. Anyway, that's just a comment. I don't mean that to sway anybody to vote one way or the other.
Appreciate that. Comments from the citizens?
I would submit that if the city of Gainesville really cared about turnout, they would have their elections at the general election in November. Because if you go do the research, you'll find that the winner in city precincts gets less votes than the loser got in the same precinct in the county election. So if they really cared, they'd have people voting on November general election every other year. Thank you.
Thank you. Mr. Wood.
Yeah, I'd just like to comment a little bit about nonpartisan elections. The document that we were given showed that over 1,000 people in Gainesville voted in the past mayoral election as independents. If we look at the population of Alachua County, that means that the other people outside of Gainesville, which is less than half, so there are probably 500 independents that vote outside of Gainesville. You know, I'm just assuming these numbers. But yet in the last general election, 158,000 people voted in Alachua County. I don't have the exact numbers, but those numbers are pretty much set in my head because we had to gather petitions based on those
How many
numbers.
were registered voters?
Now, we're looking at 158,000 people, of which about 1,500 of them probably voted as independents. But yet, when you look at the population of Alachua County and how people are registered, about 60% are Democrats. We're going to ask Democrats not to hold primaries, the majority of the people here, to allow 1,500 people to vote in that primary or to cross over. I don't see the reasoning in that at all. I don't see that improving anything at all. I think primaries are still very important. I still think it's very important to know what the party affiliation is, and I agree with what Mr. Brinkman said about being able to win an election as an independent in November. I mean, I see, that people could certainly do that if they wanted to. I also, if you recall, we heard from the mayor of Gainesville who said what her salary is and how it does not even come close to what she thinks it ought to be. And when I look at what the salaries are, I agree with some comments about how those salaries are escalating. And I think that what a county commissioner is required to do, that salary is fairly close to what they are supposed to be doing because it is a full-time 24/7 job. Maybe some don't do that, and I also agreed with what the mayor said. Instead of focusing in on what the salaries are and questioning those, maybe we ought to have them do time cards. Maybe that'd be a better idea to make sure they're actually putting in the amount, the 40 or 50 hours that's required, or maybe even, they'd be filing for overtime. I like the idea of more home rule, and I like the idea of what charter could do, but this is dangerous, and I don't like what it's talking about, and I don't like the things that are following behind it, and I'm not going to support it for that reason, because I think the way things are in this county right now, they work quite well. And is it going to improve things? I can't tell you that. I haven't done the research. I can't tell you that. But there's too much at stake here to support this. There's too much at stake here to move forward with this because it's dangerous. And I think we heard from a past county commissioner who was a past representative who came up here and said to everybody, this is dangerous. You should not go forward with this because we do not know where this may lead. So that's all I'll say about it.
Appreciate that. That's John Martin.
Yeah, I'll be really brief, Mr. Chairman. One, I just want to make clear, I never said it would increase voter turnout. And I know I waxed or waned eloquently. I never said that. And I also want to make it clear that if it were not for that write-in issue, I would not support this either, because I don't have a problem with primaries. I have a problem with the lack of opportunity. I've never said it would increase turnout, because I agree with what Mr. Laney said, and I tried to push this even in Hawthorne. The only thing that's actually going to really increase turnout is to move to the general election. People are not going to vote a lot in off-year elections. So with the county, it would probably, in a sense, potentially, in the end. And the other thing I would, and I hate to put you on the spot, Mr. Chairman, but, I really respect your leadership, and I know you're deferring and doing your role, but I would certainly love to hear your opinions on these issues as we go forward.
I appreciate that. And I've said some earlier tonight, what I'm looking for. Anyway, Mr. Glazer had some comments.
I just want to clear, you said 1,500. There's over 30,000 independent registered voters in Alachua County. So I know that's not going to change your mind because I know where you're at, but the reality is it's not 1,500. It's about 32,000 individuals that live in Alachua County are registered NPA, meaning other than Republican or Democrat. So they're Green Party, Independent, there's even Communist, or there used to be, and no party affiliation. So it's not a small number. It's huge. The reason there's 1,056 people in the city election is what Commissioner Delaney said, is turnout in the spring when the city has their elections about 16% versus 80% that we've heard tonight. And that's the difference. And so there's over 30,000 individuals that live within our community that I'm talking about opening up that process to. And I know it doesn't change your mind, but those are the real facts.
Okay. Let me
Just to respond to that, there may be 30,000 registered, but it goes back to what was discussed before. How many voted? And do we open up elections, and will they turn out more? I don't know if that's true or not.
Mr. Tuttle.
The math is a little funny. The Gainesville City election was about 16,000 turnout. 1,000 of those people were independent voters, not Republican, independent voters. The margin of victory was 39, I believe.
42.
42. So this election was won by the independent voters. You could look at it that way. That clearly is a very large change. And if you look at a larger turnout and a larger body as you would have in the county, I think you'll find that these people really do have a voice, and they're not being able to use it now, whatever word you want to use to describe that. The other thing, some of the politicians have figured this out. People who were Republicans who decide to run for the county commission suddenly become Democrats. That's happened before, and it'll happen again.
Mr. Chair. Mr. Chair, the use of the term independent is being very loosely used because, in fact, most of those people on that list would have the opportunity to vote in the primary because under state law as it exists now, every single party registered with the state holds a primary. The only thing they need is candidates on the ballot. You can't have a primary without candidates. The only people who would not, under my understanding, is no party affiliation. But a lot of those people, as has been pointed out, is Green Party. If there's Green Party candidates on the ballot, there's a Green Party primary. The fact of the matter is people aren't running for office. That's why you don't have your choices. If you want choices and you're a Republican or you're a member of the Green Party or whatever, get some candidates to run for office. That's all it takes. You don't deserve to choose the Democratic candidate. That is something for the Democrats party members to choose, not everybody.
Thank you very much.
Just a little more clarity. My numbers weren't right. The Gainesville City election was 10,250, so 10% of the people. And you're absolutely right. They could have run and had about 15 primaries and done them all partisan. And then each person who was registered to a party, American Indian Alaskan, they could have had a primary, and we could have had Hispanic female, they could have had a primary. Those are all registered political parties. That doesn't make a lot of sense, does it?
What?
What? Yeah.
I missed
Mr.
that.
Chairman,
I don't.
I've heard all I want to hear.
I'm beginning to think I should have voted on that postponement.
No, wait. I'll have to hear it all again next
That
week.
could be true. Let's see. I had another hand, but I think everything's just about
No,
been
I'm
said.
done.
Okay. Any members of the audience that I haven't recognized? Mr. Stone, come up and talk to us. Then I'll come over here. And again, the question before us right now is replacing the Board of County Commissioners with a Board of Charter Commissioners, but this is the gateway motion to a couple of others.
Bill Stone. Someone said most of the registered people here are Democrats. Now, why are they registered Democrats? It's illegal to tell someone they cannot vote if they don't register Democrat, but they do. I know some people that have been told that. They come in, and they want to register as Republican, and they say, why do you want to do that? You can't vote. So they change and make a Democrat. Concerning the status quo, certain races could not go to school or vote. That was changed. That was status quo. It was changed because of people voting and allowing races to go to school and to vote. Certain gender could not vote. That too was changed. Our people need the right and ability to vote on issues. I ask you to give us the ability to vote on these things. Thank you very much.
Appreciate that. Yes, sir. Please come up and introduce yourself to us, please.
Your voice.
I'm Eric Benson. I'm registered Republican, and I'm really a Southern States Rights Democrat, but I'm not too happy with the Democratic Party, and I figure I've got to vote in one primary or the other. I prefer primaries. I think labels mean something. And I believe that nonpartisans, they get endorsements from the party, and the Republicans typically run from the endorsement because they don't want to be labeled because they're in the minority status. I like to know that the people counting the vote, as opposed to being labeled nonpartisan, I want to know whether they're Democrat or Republican down at Pam Carpenter's office. I want to know where people are. The label may mean something to them, it may not, but it means something to me. And I prefer a primary where I know that only my folks, the ones that are somewhat in my vein of thought, are voting.
Appreciate it. Mr. Grundy.
As the maker of the motion, I wanted to just say this, and you know, if we don't like what our state is doing, not necessarily within our county, you know, we could always go to, again, pushing our legislature to change our laws to go to things like New York does. You don't have to vote in no matter what your party is. But again, it's not that way for a reason. If we want to go to a caucus, we could go do like Iowa. But for some reason, the folks in Florida don't want that. They have said that clearly they don't. So again, I don't think this is the appropriate venue. I think we need to go to the state legislature. You know, that's all I'm going to say about that.
All right. Thank you very much. Susan, if you'd like to speak. Did you say anything? No? All right. But you're talking against it. Okay, all right. I just want to be sure I was straight. Who made the motion? Please, you're recognized.
Okay. Susan Baird. I guess there's a couple of issues here, and yes, it's true. One does lead to the other. But let's also try and address specifically that question number 4, and that is whether we go ahead and replace the Board of County Commissioners with the Board of Charter Commissioners. And that, I think one of the main reasons is a great idea is, again, because you have more of this home rule thing. And I hadn't ever heard of this home rule before either, but what I'm gathering is that it means that we have a better opportunity to make decisions about our government in our particular county a lot better than if it were left at this other status quo. And I know change is always hard, and it is a little scary, but sometimes change is a better thing to do in the long run, especially when you can govern yourself even better with a charter committee versus a county commission. So that's one of the main reasons that I do encourage you to go ahead and vote for this particular question to be put on the ballot. And again, a lot of people in the history of time have always thought they had the best idea. And they may have in their mind, but it may not have been the best idea. But because that's what they thought, that's what they decided to go ahead and try and get everybody else to think the same thing. The basic fundamental premise for all of this is better representation, citizen involvement, and we had the whole list of why we should consider something, and then, of course, let the people choose. And if it is such a bad idea, they will not vote for it. If it is a good idea, then they will vote for it. So again, put this on the ballot is my recommendation. Thank you.
Thank you. Further comments? Are we ready to vote?
I think Michael, he's just standing up.
Okay. Further comments? Seeing no other hands up, that looks like we're ready to vote then. The-
Voting on just number 4.
Just number 4 at this time, which is replacing the Board of County Commissioners with a Board of Charter Commissioners. That's the only question before you, along with the attendant or companion ballot language and resolution that was prepared by our attorney.
You can say the affirmative first, and then
Okay, all right. Anyway, those in favor of this motion should vote yes. Those opposed should vote no. Greg, if you'll call the roll and then announce the results, and if you can give us the yes and then the no.
Mr. Ackerman?
Yes.
Mr. Brinkman?
No.
Ms. Ferguson?
Yes.
Mr. Glazer?
Yes.
Mr. Grundy?
No.
Mr. Irby? Mr. Little?
Yes.
Mr. Abronsi Martin?
No.
Mr. John Martin?
Yes.
Mr. Richard?
No.
Mr. Tuttle?
Yes.
Ms. Martin?
Yes.
Mr. Wood? No. Mr. York?
Yes.
That passes with 9 yeses.
9 yeses and 5 noes. Is that correct? Correct. All right. Well, thank you very much for your counting those votes and announcing the rest. And so by your votes, that question has now been agreed to, 9-5, and received the requisite 8 votes. So thank you very much for your.
I move whatever's next on the list.
Mr. Little has moved. All right. Mr. Little's moved question 5, nonpartisan election of Board of County Commissioners, which is, again, if question 4 is approved by the voters, then this would come into play. Are there comments? Mr. Little, you wish to comment on your motion?
We've heard everything we need.
Okay.
I second that.
Thank you, sir. All right, further? I know we discussed that as part of the previous motion in great detail. Any citizen would like to come forth on this particular motion? Again, this is a nonpartisan election, Board of County Commissioners. If 4 is approved by the voters and the voters approve this, then this would come into play. I don't see any hands. Don't see any hands. Greg, call the roll and announce the results.
Mr. Ackerman?
I'm torn on this one. I'm going to vote no.
Mr. Brinkman?
No.
Ms. Ferguson? No. Mr. Glazer?
Yes.
Mr. Grundy?
Nope.
Mr. Irby?
Yes.
Mr. Little?
No.
Mr. Abronsi Martin?
No.
Mr. John Martin?
Yes.
Mr. Richards?
No.
Mr. Tuttle?
Yes.
Ms. Martin?
Yes.
Mr. Wood?
No.
Mr. York?
Yes.
It fails with 6 yeses.
6 yes, 8 noes. The question 5 then is not agreed to, and it will not appear on the ballot. Number 6,
Everyone just go down just go down the line.
setting salaries of the Board of County Commissioners.
I'll actually move for it.
The Mr. Who moved that?
Second.
Okay, Mr. Little. Mr. Little's moving. Okay, thank you very much. We have a motion and a second on number 6.
Watch that.
Any Commissioner Delaney?
I have a question on, I don't know if I'm in the right place, but it's
Okay.
this page 2, question 6, May 12th. Is that what y'all
That's
are
it.
working from?
Yes, ma'am.
It says down, there's underlined near the bottom, line 18, the salary in effect at the beginning of a commissioner's term in office shall not be lowered during that commissioner's term. So let's say that the Charter Commission passes. We have 2 commissioners elected this year. Does that mean the 3 sitting commissioners that don't run for 3 years could set their salaries at $5,000 a year while we earn the difference?
I think there may
Could we
be a
set our
motion-
salaries at 100?
I think there may be a motion that addresses.
So I just, to me, I mean, I have to tell you, as I've always felt like to some extent that there ought to be some way to quantify if someone's been there 8 years versus 1, but there's not really. But I would have serious problems as someone sitting there if if there was a great deal of discrepancy, because we're all going to pretty much do the same amount of work. And just for the record, I am a commissioner who has always been willing to deal with the salary, and I don't believe people should be involved in public service if they're there for the money. And so, That's just my
Thank you
opinion.
for this
Thank you. I'm
comment.
not sure that would reflect the rest of the commissioners.
Mr. Glazer.
Mr. Chair, I would move that we strike lines 18 and 19. I think the rest of C speaks to the heart of what we're trying to accomplish, and it puts it in the hands of the county commission to make their own determinations of their salary levels.
Second.
Moved and secondly, strike 18 and 19, which is the salary in effect at the beginning of commissioner's term in office shall not be lowered during the commissioner's term. And again, this is allowed because of the changing to a charter commission, because under state law, that would not be allowed.
Mr. Chair.
Yes, sir.
Picking up on your point, I agree with Commissioner Grundy. The proper way to do this, and by the way, I believe it was Commissioner Ackerman who originally proposed this amendment, and I liked it far better than arbitrarily lowering their salary to half of the median income or the median income of the county. I really thought just speaking to the accountability was the way to go. However, again, I don't think this charter commission concept is sound. I think the proper way to do this is through a special act of the legislature. If we can do it for campaign finance reform, get a special act of the legislature and pass a charter amendment, we should be able to do it for our commissioners' salaries. And we might even find our commissioners supportive of the idea, at least some of them. So I'm going to vote against this because I don't think it's the proper way to do it. I think state law provides the way to address these things, and that's the way we should do it, even though I do believe commissioners should be accountable for what they are paid.
Thank you for
I
this
have
comment.
one more question. Would we also be setting the salaries for the constitutionals?
That is not before us.
Okay.
Okay.
Then I had
You got to be recognized.
I had one other question, but now it has slipped out of my mind.
Okay, I'm going to recognize Mr. Wood down here, I think.
What do you got?
Oh, Mr. Martin. Okay, Mr. Martin.
I spoke to you earlier about what the facts of how this came about, and what in my opinion, is unintended. The facts I said of how it came about were absolutely true. The unintended consequences is certainly my opinion, but I think if you look at the salaries, it does that. As someone who has actually sat on a board where we had to cast votes to raise our salary, when it was justified, we actually had very little opposition. Of course, we were only making like $250 a month, so it's pretty hard to argue against that, But I think when it's justifiable, you won't find as much outcry. And all this is really doing, everything else aside, all this is really doing is making the county commission accountable in the same way that every other elected body all the way up through the U.S. Senate has to do. Okay. And so, to me, I would like to see someone make a case for why they should be set aside. Because I don't think you can. All right. But that's what.
I'm not going to recognize you.
I think
All right.
we addressed just.
Mr. Chairman, could we get the meeting back on hold here?
All right.
We addressed that in the first issue.
Let me just ask the audience to conduct themselves the same way that they would be expected to in other meetings.
And the committee.
And the committee also. So let's
I
one
did have the
speaker.
floor, I think.
That's right, you did. One speaker at a time. The motion before us right now is an amendment to the, which is striking lines 18 and 19 of the proposal. Further comments? Further comments?
Yes, Mr. Chair.
Mr. Grundy.
Again, I think we should. I'm torn on this issue, but like I said before, I don't think it's the appropriate venue. But the reason why I'm torn on it is because you hear folks within our county, almost every resident said this is the best part-time gig in Gainesville. I mean, to get paid $70,856 a year, that's the best part-time gig in Alachua County. I misspoke. But it's again, I think by putting Mayor Hanrahan put some words of wisdom to us when she said allow them to use. We're not doing the time card thing, but putting it in control of them to allow them to set their salaries is making them accountable, and that's why I'm torn on this issue. But I'll listen to my colleagues too.
Thank you very much. Further comments? Comments from the audience? Seeing none, I think then it appears we're ready to vote on this issue, which is on the amendment only on the amendment. That's to strike lines 18 and 19, dealing with the salary during the term of office.
I'm sorry, what?
Yeah, could we get clear?
Could you say the amendment a little louder, please?
I'm sorry. The amendment is to strike what are known on the document as lines 18 and 19, and those words are, "The salary in effect at the beginning of a commissioner's term of office shall not be lowered during that commissioner's term." So that's-
The motion is to strike that language.
Strike that
18
language.
and 19.
Strike that language. That will leave the salaries and other compensation of charter commissioners shall be set by county ordinance. That's what it'll leave. Okay? Greg, call the roll.
Mr. Ackerman?
Yes.
Mr. Brinkman?
Yes.
Ms. Ferguson? Mr. Glazer?
Yes.
Mr. Grundy? Mr. Irby?
Yes.
Mr. Little?
Yes.
Mr. Martin?
No.
Mr. John Martin?
Yes.
Mr. Richards?
No.
Mr. Tuttle?
Yes.
Ms. Martin? Mr. Wood?
No.
Mr. York?
Yes.
The yeses have it. 11.
11 to 3. Thank you very much. And by
Let's
your-
vote on the motion.
Okay, we're now ready to take up the motion as amended. The motion as amended.
Our parliamentarian.
Yeah.
No, just tired.
Further comments on the motion as amended? Seeing none, any from the audience? Seeing none, we're ready to vote. Greg, call the roll, announce the results.
Mr. Ackerman?
Yes.
Mr. Brinkman?
No.
Ms. Ferguson?
What are we voting on, question 7?
6.
Question 6, salaries of the Board of County Commissioners.
Oh, that was the amendment. Okay.
Question on the salaries of the county commissioners.
Yes.
Mr. Glazer? Mr. Grundy? Mr. Irby? Mr. Little?
Yes.
Mr. Abrancy Martin?
No.
Mr. John Martin?
Yes.
Mr. Richards?
No.
Mr. Tuttle? Ms. Martin? Mr. Wood? Mr. York? The yeses have it. 10 to 4.
Mr. Chairman, I move number 7.
By your votes, then you've agreed on question 6, and so it will move on forward to ballot. Question 7 has been moved by Mr. Little and has been seconded by Mr. Grundy. We appreciate that. And are there any comments on question 7?
Yes, Mr. Chairman. I speak in opposition to question number 7. Primarily, and this goes to a specific office, it is my opinion that the office of sheriff is not merely an administrative office. The arrest power is the most awesome power any government official can have. The sheriff is, by virtue of the nature of the office, does make policy. I go to first appearance in the day when they decide they're going to make a sweep, and that's because the sheriff decides to do that, or the command structure. So I have to, as Commissioner Grundy is fond of saying, take a line from Commissioner Little. We, this board, since this board makes decisions in the collective, hadn't did an evaluation of the consequences of removing the constitutional status of any one of these officers. We haven't heard from any one of these officers whether or not they believe their function would be impeded by no longer being a constitutional office.
Our current proposed, just correct, they're still going to remain constitutional officers. The current proposed
Oh, okay.
change is nonpartisan.
Oh, well then, you know what?
Okay.
This is what happens when you
At 11 o'clock.
when it's 11 o'clock and you're on the so it's just nonpartisan election.
Right.
Well,
That was our latest change.
Never mind.
well, not completely now. I still speak in opposition of it, but all the other stuff.
Right.
No, yeah.
Mr.
And I appreciate it.
Chair, as I recall, because I think I was the one who made the motion, this was originally to change the constitutionals to charter commissioners. To charter officers, rather, excuse me. It is late. And thereby change the elections to nonpartisan. And what I'm asking is, when did we vote not to do that and instead leave them as constitutional officers and merely make their elections nonpartisan? I think that the attorney proposed a revision, but I don't think we've voted on that. And I believe the last form that this body voted on it was to change the constitutional officers to charter officers. And that has a significant difference, specifically to Mr. Abrancy's comments about the sheriff.
Oh, I'm not a
Because
busy one here.
as a charter officer, it would be possible in the future to change the charter, the sheriff, from an elected officer to one under the control of an elected body, the Board of Charter Commissioners, if it be that, or the Board of County Commissioners.
Are you going to make a motion?
And that's, well, actually, what my point is, I think actually the motion before us should be to change the constitutional officers to charter officers and to make the elections nonpartisan.
That was what I intended to put on the,
Okay.
which I agree, I think is what we had approved.
Right.
It was.
Being manipulated by our lawyer.
Okay, well, what?
Inadvertently, I think.
Well, I think it came about whenever we were looking at the, how to get to where you were getting, and frankly, if that's the case, and
I'm not
and you
assailing
may-
anybody of
I
any
understand.
conspiracy theories or anything. I'm just pointing things out.
Well, then, since Mr. Little made the motion, I will take it that you made the motion that they may be made charter officers. That's your motion, and that we revise and amend the question to reflect that.
Well, wait. Okay, I'm sorry.
We have a ballot question
Now your
somewhere
objections
on
are
that.
valid.
Yeah.
All right, you're back in, Abronsi.
Well, no, just to clarify, now I'm looking really sleepy now, but it seems like that's where we were from the beginning. That I think Commissioner Brinkman saying that was just a suggestion from our attorney that we do that, but we never voted on. Is that correct? Is that what
That's
you're saying?
correct.
So the motion before this body is abolish constitutional officers and replace them with charter officers. Is that where we're at?
That's it.
All right. Well, I'm in opposition for all those
back to the original.
neat things I was saying before.
Can I clarify that? The whole issue was at the end of the last meeting, and it was over the word abolish.
Right.
And that was the only thing that we were sort of contemplating changing, taking out abolish because it was too harsh, and leaving everything the way it was so that it says to requiring the constitutional officers to be replaced with charter officers and elected nonpartisan.
Thank you for refreshing our memory. That's where it did come about because I think in the Constitution it uses the word abolish, and so we were trying to get by that and not abolish the office. Am I correct? That's.
Well-
I think you've refreshed my recollection. Thank you.
Well, Mr. Chairman, if I'm, you have to, if you're going to make them charter officers, and I think what the Constitution says, you actually have to abolish them and then transfer their, all their duties and all their, to a new office, which I am adamantly opposed to. But that's what our lawyer, and that's, and I agree with you that would, I know that's rare. But I agree that if you're going to do that, that's how you got to do it, and I don't think it's a good idea.
Okay. Thank you very much. Any other members wish to? Mr. Grundy.
I concur with everything that Abronsi and Commissioner Wood said.
Okay. All right.
Mr. Chair.
Yeah, which version are we?
Okay, I'm looking right now. What we're doing is, Mr. Little's motion is that we actually revert to the previous edition of abolishing the offices of constitutional officers and replacing them with charter officers with the same duties, same responsibilities. And I've got, here it is, right here. I've got it right in front of me. It says, shall be abolished and replaced with charter officers of the same respective names and be chosen by the electors in a nonpartisan election. The charter officers' powers, duties, and functions shall not be altered by this Home Rule Charter. The charter officers shall perform their respective executive and administrative functions as specified by law for constitutional officers of the same name. So that's where we are. This is the
You
one
reading from the May 12th?
I'm reading from the April 16th, and there may be a May 12th.
I think
But
May 12th is the same.
okay, okay.
And, Mr. Chair, I have a question for...
Yes, sir.
Probably for the attorney. Under state law, as I currently understand it, the sheriff, as a constitutional officer, has a unique power, and that is if she disagrees with the budget that she is provided by the Board of County Commissioners, which must fund her, she can appeal to the governor and cabinet. Now, if we abolish the constitutional office of sheriff and make her a charter officer, and I'm only using the female pronoun because the current sheriff happens to be a female, but would that then eliminate the ability of the sheriff to appeal to the governor and cabinet? Okay. But a future charter amendment could change the entire office of sheriff to one something like, you could put it under a director of public safety. The point I'm getting at here is I think if you talk to our commissioners, one of the biggest drivers of the rapid increase in the county commission's budget is public safety in general, fire and sheriff, and one of the larger components of that is the sheriff. Now, I don't want to throw stones at the sheriff saying that she's spending money poorly or anything like that, but it's just that those are the facts, and it was true under the previous sheriff. It is kind of the nature of the animal, but the problem is the people who are elected and have to levy the taxes to fund the county government are not able to control where a significant, or not able to control as fully as they really should be able to, in my opinion, a huge portion of the budget, which makes managing the rest of their budget really difficult. And that's why I am interested in taking this turn for changing the constitutional officers to charter officers.
As,
Chair.
Ms. Ferguson.
I have a question for the attorney. Hypothetically, if both of these items move forward and they're on the ballot, one could pass and one may not. So let's say we have charter commissioners and constitutional officers. Is that some type of inconsistency in?
Just in the way the electorate feels. No, I don't think that would be a legal problem.
Okay,
Because there are separate constitutional provisions governing each.
okay.
All right. Further comments? Further comments on question 7? Citizens. Yes, ma'am. Susan, please come forward.
I'm not sure about this whole changing from county,
Constitutional.
from the constitutional to charter. I'm not sure about that. The one thing I think I feel very strong is that these positions are very important, and to be partisan, I just think that, to me, that almost kind of rubs me the whole wrong way. These are, this is supervisor of elections, this is the sheriff, property appraiser. That clearly should not have any type of Republican, Democrat, Independent tone. It's the law, and yes, it's true, they do have, everybody has some leeway, but at the same time, these are just too important and too straightforward, I think. I can't believe it's even an issue, but let's, my suggestion is to go ahead and put it on the ballot and let the folks decide on this, because it is very important. Thank you.
Thank you for your comments. Ferguson.
I'm just wondering, how many other initiatives would be on the ballot in November, the state
Right now, I
initiatives?
think there's 9, more than 9? I lost count.
13.
13.
13? Wow.
I think it's 13, am I?
I don't know. When I asked the supervisor election day, she said 9.
9. There's also one that's a straw ballot question that the legislature put on about federal budgets.
Okay.
So maybe they're 10.
It'll be a long ballot.
Very
in
long.
November. Okay. Further comment?
Mr. Chair, I'd just like to quickly observe that I think if we stay here long enough and keep talking long enough, any one of us will find that we're in agreement with somebody else. And I just want to note that Ms. Baird and I are actually in agreement on the question of nonpartisan constitutional office.
We're coming around. This reminds me of, I'm sure those of you that watch the legislature know that last day is a dangerous day because, when they stop the clock and do all that kind of stuff.
I was just wondering, could we tack on a mandate to stop the oil spill?
Yeah, I wish we could. All right. Then, are we ready to vote? I'm not seeing any hands. All right. The question before you then is requiring the constitutional officers to be elected in a nonpartisan election.
No.
No.
I'm
Charter.
sorry.
I want to go. I did want to postpone this.
Thank you very much. Abolishing the constitutional officers and replacing the charter officers elected in a nonpartisan election. The only thing I would ask on any of these nonpartisan, does our attorney feel like we should identify at all, or does it go without saying that all these nonpartisan elections shall be handled pursuant to Chapter 105, which is the nonpartisan election chapter in the state statutes? Do we need to define that at all, or does that go without saying?
You asked me that question or posed that question in an email earlier today. Two ways to go on that. One is to do that and to tie it down. The second one is, the second view is that what happens if the legislature changes the chapter? And then what do we do? We've got a charter now that requires something that no longer exists. But I guess the answer to that is we could change the charter later. So
Well, if you feel like that's the procedure that
would be
there wouldn't be any question, that's what would be followed. That's
Right.
all I care about. Okay, thank you very much. All right, further comments? Seeing none. I'm sorry. Well, I think we're.
That was on the other.
Well,
If I may?
we had talked about that, but it's not Mr. Little's motion at this time.
Well, Commissioner Wood, if I may, I think the problem is that state law says that you can do this to constitutional officers, but it specifically says you must abolish the constitutional office. So it's kind of a matter of, it's what the law says. I agree with you about the harshness of the term abolish and about the fact that much of the electorate is liable to look at that and just based on an anti-government frame of mind is going to vote for it. But
yes, we're in an anti-government movement here, and it's been going on for some time. And when people see abolish so-and-so, they're not going to read anymore. They're going to vote for it. So I think that's a little dangerous, you know.
All right. Further comments? Seeing none, Greg, are you our counter again? If you'll call the roll, announce the results.
Mr. Ackerman,
Yes.
Mr. Brinkman,
yes.
Ms. Ferguson, Mr. Glazer, Mr. Grundy, Mr. Irby,
Yes.
Mr. Little,
Yes.
Mr. Abrancy Martin,
No.
Mr. John Martin,
Yes.
Mr. Richards,
Yes.
Mr. Tuttle, Ms. Martin, Mr. Wood, Mr. York, 12 to 14, yes.
12 to 2.
Mr. Chairman, is there anything else
We
we
understand.
can vote on tonight?
Mr. Little, there is not, if everybody understands where we are.
Well, one moment. Mr. Chair, if I may. Earlier tonight, you gave out some certificates of appreciation to staff, and I think that was quite well. I'd like to actually move that staff prepare similar certificates of appreciation and get the names of the members of the public who have stayed in the office for an almost 6-hour meeting, because as somebody who has sat through commission meetings till after midnight on many occasions, I can tell you that people rarely do that, and
I'm
I
very
want to
proud of it.
congratulate them for sitting through meetings for 6 hours.
This makes about my third
back on the,
long meeting today. I can tell you that, and we'll be back at the office at 8 o'clock in the morning.
And
Those
the
in
next
favor of the
meeting
motion to adjourn, say aye. Opposed, no. We'll see you in 2 weeks. Mr. Little, thank you so much.